and to the republic which stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, pursuant to the Open Public Meeting Act, the South Jersey Times and the Sentinel were notified of this meeting. It was also posted in the municipal building on our webpage. And that's it, I think, right, Tracy?
Yep. Mr.
Take roll,
Gaetano?
please.
Mr. Gaetano? Mr. Leo? Mr. Ketchum? Mr. Garofalo?
Here.
Mr. DeCesare?
Here.
Mr. Hamel?
Here.
Mr. Tarasca?
Here.
Mr. Iglesias?
Here.
Chairman Gravener?
Here. Okay, in the absence of Mr. Leo and Mr. Ketchum, we'll see our two alternates, Mr. Tarasca and Mr. Hamel. Okay, the minutes of the previous meeting, that would be June. Is there a motion to approve those minutes? Motion by Dan DeCesare, second by Richard Iglesias. All in favor?
Aye.
Opposed? Any abstentions? Okay. All right, we'll move right to our agenda then. First on our agenda tonight is ZB25-08 in the name of ARCR Properties LLC. Please come forward.
Call Mr. Gaetano back there. The minutes to Shirley Drive.
I have it reflected in the minutes. Do you want me to?
No, just make sure it's reflected in the minutes.
Yeah,
Here.
I have that.
Everything in order?
Notice, yes.
Oh, we said, for the minutes, Mr. Gaetano is seated on the board, arriving late.
It says 7 o'clock. How you doing?
7 o'clock means 5 or 10 off. We're waiting for you. Mike, everything's in order, right?
Yes.
All notices?
Yes.
Okay, sure.
Good evening, everybody. The board is familiar with this property. I'm sure I'm not sure if the microphone is working. Can you hear me now?
I don't know what to say then. Is it working? I mean,
It
you're
is. I
speaking into
can
the
hear it.
microphone.
Okay.
I can hear it. You probably can't hear it over the air, but it's working.
As I was saying, I'm sure the board is familiar with this property and me at this point, but my name is Scott Good. I'm an attorney with the law firm of Cooper Levinson. We're here to present the application for Zero Main Road, which is block 5702, lot 55 on the tax map of Franklin Township. The property is a flag lot. This is a flag lot that was created by subdivision by this board a long time ago.
Not this board, or wrong.
A private-
Correction, by the planning board.
Oh, by the planning board, I apologize, you're correct, by the planning board. The applicant is proposing to construct one single-family residence on the property. We're asking the board to grant one variance for lot frontage. We have 10 available feet along Main Road, and the ordinance requires 150 feet linear feet. The property is located in the RA Residential Agricultural Zoning District, and where single-family residential homes are an approved plan, approved use. So, I know we've been here before, and I just wanted to preface our presentation by addressing some of the issues that were raised in the review letter, one of which being our prior application proposed to enter the property through an easement on lot 54. There was testimony from the owner of that property regarding that, which, regardless of how this board ruled at that evening, we would have gone back and looked at it. So we did order a title search after the fact. And that easement, we've determined, we don't believe that it would have been a valid easement. So the only access point that we have right now is to the property is the 10 feet of access along the main road. So with that being said, I have two witnesses tonight. Mr. Richard Rosenberg, who is the manager of ARCR Home Builders, as well as Kyle Denny, who is a professional engineer and land surveyor with Basins Maintenance Plus. So,
Is that right, Mike? That's the only access, that easement doesn't?
Yes, so last time this was heard, you requested the same thing you're requesting tonight, it was put on hold because the board thought that easement was what should have been used.
Right.
I did take a look at that.
Correct.
So then that's what they took a look at that easement. Turned out that easement was not valid. I do agree. So that easement not being valid puts them back to now the original request, which you did not make a decision on. The original request being accessed by this 10 feet, which is the only access unless an adjoining property owner wants to sell them land or an adjoining property owner wants to purchase the property.
Okay.
And we've had no offers to purchase the property, and with the previous applications, we sent out letters for both, and we've received no response. So but my client is simply looking to build a single-family home, and we'll put on our application for the record.
Okay.
Chairman.
Raise your right hand, please. You swear to tell the truth about the testimony you're going to give.
I do.
Your name and record, and obviously your credentials.
Kyle Denny, Base Maintenance Plus, PO Box 120, Franklinville, New Jersey. I'm a licensed engineer and a licensed land surveyor in the state of New Jersey. And previous testimony in front of the board.
Yes. All right, thank you.
Have you been recognized as a professional?
Yeah.
Can you describe the application a little bit?
Yeah, so we have an existing property which is rather large in size. It's over 12 acres, which is existing, and currently accessed by a 10-foot wide flag portion, which was previously approved, that created this lot. The two adjacent lots immediate to it are 135 feet, so they are not conforming either. The requirement's 150.
So, in terms of the bulk standards, are there, besides the lot frontage, are there any bulk standards that are non-compliant with the ordinance?
All other criteria are met for this property.
What is the current condition of the property?
It's wooded vacant land. However, some of the adjacent neighbors have used it to dispose of brush and trees and cut down trees, as well as they have paths going through the property for hiking and riding bikes, dirt bikes, or whatever.
What is the size of the property?
It's over 12 acres, 12.26.
Some of the concerns that were raised previously were with respect to drainage from this property. How do you see that being affected?
So the municipality has very stringent stormwater management regulations, which we would adhere to if the project is, the variance is approved.
Have you reviewed the report of Mr. Shivik? Do you have any comments or concerns regarding that?
No.
Yeah.
We're going to go through his report, so
Absolutely.
if you want to do it now, we can do it now. If you're going to address some of his points, let's just go through it, Dave.
Thank you, Chairman and board members. Our report was dated June 17th, 2025, in which we reviewed this application. This is in the RA Residence Agriculture Zone. Minimum lot size in this zone is 1.5 acres. The applicant's property is 12.26 acres. The variance that's being requested tonight is for street frontage. 150 feet is required in this RA zone, and the 10 feet, as we heard, is what's being proposed. That is the only frontage available to this property as it stands there today. The applicant proposes to construct a single-family dwelling. My paragraph 2 talks about that lot variance of 10 feet. Paragraph 3 in my letter just gives a little history that Mr. Good had said about this application previously being denied before the board to use that easement. That's no longer valid or available. We had asked if attempts were made to acquire additional frontage, and just for a point of reference, the driveway is 970 feet long by 10 foot wide, and we had a concern in our report about making sure the driveway was able to support the weight of emergency vehicles. Other than that, it's pretty straightforward. We're really down to that lot frontage variance. That's the only issue that needs to be resolved.
Can you talk about the next two vehicles?
Yeah, so in the state of New Jersey, the allowed width for axles or tire widths for vehicles is 96 inches. With special permits, you can go up to 102, which is 8 feet, 6 inches. Right now, we're proposing a 10-foot wide driveway. I know previous testimony, there was concerns about that being right on the property line. So if we were to shrink that driveway down to 9.5 feet, that would give us 9 inches of buffer on each side of the tires for the fire truck. Now, the width of the trucks are 9 to 10 feet wide on average. So that would provide adequate access coming into there. And then that would give us 3 inches of buffer on each side of that driveway to the property line. And then also, on the previous application, there was testimony provided by the adjacent landowners regarding clearing of the property, concerns with stormwater management. If we were not here seeking a variance for lot width, we would just be going getting building approvals, and we would be able to build on this lot no matter what. So the fact of clearing lots for stormwater management should have no bearing on the decision for the variance. It's more of support, is there adequate access, and is it safe access into the lot?
So can you just talk about a little bit about how the development of this lot will benefit the township?
So with respect to the variance, support can be provided under the C1 hardship, which, as we've indicated, there's no room to acquire additional property. And this adjacent property is undersized already, so if we were to acquire more of that, you're driving that property further into non-conformance and creating a new variance situation. Additionally, requirement can be provided under item A for appropriate use and development. The reason for the municipal land use law is to guide appropriate use and development of all lands in the zoning districts. Additionally, under sub-item G for sufficient space, as we indicated, we're well exceeding all the requirements, zoning requirements from setback and lot area, and then also population density. We have one lot on 12.25 acres, where the adjacent lots are about 1.5 acres. So we're about 8 times the lesser in the density.
Mr. Kennedy, in your opinion, can the variance be granted without substantial detriments or hardships to the project?
That's correct. So there are previous other lots in the RA zoning district that have been approved as flag lots, and there's a number of undersized lots in the zoning district, so there's no detriment or impairment of the zoning plan ordinance.
And in your opinion, would the benefits of deviating from the zoning ordinance outweigh the detriment?
Yes, because as I indicated in item A, it's sufficient use and development of all lands throughout the municipality.
And last question, would granting the variance impair the intent of the zone plan or the zone plan?
No, it's in conformance with adjacent lots with respect to throughout the whole RA zoning district.
So, you did say you tried to purchase additional land, and there's none for sale or available.
And I think that you will hear shortly that there is no interest in selling.
And how about you selling to neighbors there that might want to buy? Is there any?
You might under consider selling the property for fair market value, but no offers accepted.
And I just have one question, because we have one of our fire chiefs here, and how you feel about that 10-foot wide. Is that adequate for a fire truck to get?
I got drawings of a fire truck right now that we're purchasing. It's 100 inches wide, not counting the mirrors and anything else hanging off the side.
Okay, so 100 inches, that's 8.5 feet, right?
8.5 feet.
So right now we have 10.
That's
But-
8.5 feet just tire to tire, outside the tire. That's not counting the running board, the valves we have hanging off the side, or the mirrors.
I have a question for you. If there were to be a house fire, would there just be one fire truck that would respond to that fire alarm?
No,
So you have one fire truck?
we're the
that
first
is-
due ladder.
Okay. So usually ladders are more for like high commercial buildings?
No, they're not
and that
all the
stuff.
time anymore. That's the policy. If you have solar panels on your roof, you have to have a ladder there to fight the fire from above.
Yeah, we wouldn't be putting solar.
You don't know that.
What if we live in a hospital full of things?
I mean, as a condition of approval, we could, put a restriction on it that it would be no solar panels, but are there any other ladder trucks in the municipality in the fire?
Yeah.
But can the truck get that thing or not?
It'd be tough because I'm assuming there's trees on each side of the driveway,
Well, we would have 10 feet wide, that would be clear because the property goes.
and somebody's gonna keep that maintained all the time.
That could be part of the AP restriction or some, so we can work with Mr. Borelli on how to do it.
But again, that's just that one new fire truck that we have. Not all fire trucks meet those requirements.
I couldn't tell you what the width of our pumpers are, but they're probably as wide as that truck is.
But with 102 inches is 8 feet, 6 inches.
It's also an 80,000-pound truck.
Well, you're down the highway, you're allowed to have that.
Yeah.
8 feet, 6 inches, that's,
102, that's a 102 axle.
yeah.
And then if
That's
we
what
have a
that's what
9.5
most
foot.
trailers are.
Yeah, if we have a 9.5 foot wide driveway, like I said, right now we're proposing 10, but if we shrink that down to 6 inches, we would still have 6 inches on each side. And that's just for the initial stretch, the beginning. And then once we get by to that, we could expand it out in sufficient space.
And why don't we open up to the public?
Before you do that, John, just comment on that. I'm not sure the board has to make a determination about the adequacy of the access. I think that may be something they would have to deal with to get their driveway permit and their grading plan and all that might be part of it, I don't know. So I don't know if you necessarily have to make that determination. You can if you want. But I have one question, maybe Dan, you can answer it. If there's an emergency, I assume the truck can use whatever space they need to get to the fire, whether it's that property, somebody else's property, the rear.
Yeah, but I'm not gonna drive, I'm staying on a driveway surface. It's an 80,000-pound truck, I can't drive across somebody's backyard.
So the only solution you would have would be lot 54.02, giving you more land. That would be the only thing that would solve the problem.
And we know the thing.
And that would drive that further into a variance.
All right, Mike?
Yes, that's all.
Okay, so is there a motion to open up to the public?
I make a motion, we open the public.
Danny the Cesare. Is there a second? Second it. Second by Mike Garfolo, all in favor, aye. Anyone here from the public like to be heard regarding this? Please come forward. You only have 3 minutes, remember. 3 minutes. Raise your right hand, please. You swear to tell the truth about the testimony you're going to give.
I do.
Name and address, please.
Lucas Coastal, 130 Whitetail Pass.
Thank you.
So I took the time to draft this in letter form so that I can be efficient in my speech. So good evening and thank you to the board for allowing the residents of Franklinville a voice in the determination of the proposed home. My name is Lucas Coastal, reside at 130 Whitetail Pass. My wife and I purchased a home in Franklinville in 2007. What drew us to this area was the small town charm, wooded lots, allowing us to raise our 3 children in a small development that balanced having families for our children to play with and at the same time maintaining the privacy in the home that we currently live. At the time, it was expressly stated that the wooded lot behind our home was not buildable and was landlocked. To my knowledge, this is the 3rd time, and after speaking to another resident, I found out that there was another meeting in December to which I did not receive any notice. I'd like to ask the board to consider a reasonableness when it comes to this situation. Why is it that one individual can continue to petition the board for what I would consider to be an unreasonable variance relief from 150 feet down to 10? There are 25 families or homes impacted by this decision, all of which comply with the zoning regulations of this town. Our home values will be impacted by this decision. Each of the 25 residents will have their homes and now have somebody build their home in our backyard. Privacy. In keeping with the proposed building site, this individual will now be living and driving behind each of our homes on a daily basis, eliminating the privacy that this wooded lot would now offer between the 2 developments, Lewis and Whitetail Pass. This will substantially impact the privacy for all of these residents. I'm trying to go as fast as I can. Environmental impact. Has a feasibility study been conducted? It sounds as though there's been some type of study. I'm sure you're aware of the engineering errors created by Signature Homes, the previous builder. There is a constant running of our sump pumps on Whitetail Pass. You can't tell me that with 900 feet of driveway directly behind these homes, that will not increase the flooding scenario behind our houses. The amount of rainwater when it rains is significant behind our homes, and it collects at the back end of our development. Currently, the retention basin off of Lewis is completely overgrown with trees growing in it, and the retention basin for Whitetail Pass has never worked properly and drains directly into our backyards and is systematically killing the trees in our lots. The introduction of a clear pathway for this water will only exacerbate the issue. Currently, there's an easement restricting permanent structures within the last 100 feet of our properties. Additionally, the last 60 feet is identified as conservation easement, restricting any disturbance. How is it possible for this waiver to continue? May my wife finish my
I'm sure
statement?
that you object.
I'm sorry?
You're against the variance.
I would say that I'm against the variance,
Okay, I think that's
given the
enough.
statements,
We get-
given the statements that the stormwater has no bearing, the stormwater assessment that has been done has no bearing on our development. It will, in fact, have an additional bearing on our development, and there's no discussion of that. I want to be respectful of people's time.
All right, thank you. Anyone else like to be heard? Well, raise your right hand, please. You swear to tell the truth about the testimony you're going to give.
I do.
Name and address.
Kevin Henson, 2635 Main Road. I'm the house directly next to what they're talking about. Our easement was done 20 years ago when the house was built. Just like we couldn't build now because I believe it's changed to, 2 acres at least, so we're just under the build. And as far as their 10 feet, our property line converges with the neighborhood. It makes it 8 feet at the back corner of my lot. So they're 10 foot, but they're telling you guys it's BS. You shut them down last year because of the width of the fire trucks, which they're still trying to push. And as far as them reaching out to anybody to buy, nobody either has the money or wants to buy the land. That's why it's been vacant. The current owner hasn't made any attempts to maintain the property, so they're telling me it's going to be maintained by who? I have dead trees overhanging my property. They've had a surveyor out. Have they tried to take any leaves or anything? Not at all. So it's just smoke and mirrors. They're trying to get you guys to ram this through, build the house. We're all shafted because we live there. They make their millions and move on. I don't think it's going to be good for the town. I think it's going to open the town for future litigation from the neighbors of Whitetail Pass and this gentleman said. Everybody with sump pumps and water runoff, if this is granted, they're going to be pretty pissed that the basements keep flooding even more. So, I mean, it's, sorry for the crudeness, but it's a little, aggravating living next door. This is now the third or fourth time. So, for what it matters, we got decision. We're all no's. So, thank you for your time.
Thank you. Anyone else like to be heard? Raise your hand. Swear to tell the truth about the testimony you're going to give.
I do.
Name and address.
Tara Royce, 2647 Main Road, Franklinville, New Jersey. I oppose. We've been here last year for the same exact situation, and I don't understand when we have the conversation what we've changed about your thinking today versus what it was a year ago. I'm opposed to it, and I'll leave it short. Thank you.
Thank you. Anyone else? Please come forward. Swear to tell the truth about the testimony you're about to give.
Yes, I
Name and
do.
address.
My name is Carmen Palutra, 122 Whitetail Pass. I oppose, and I agree with all my neighbors, what they're explaining to you. I remember when I first moved in, we had major problems with the cul-de-sac. Fire department couldn't turn, school buses or ambulance could never turn. While we were living there, they had to redevelop the cul-de-sac to turn, not once, but twice. So I can't see how they're going to be able to pull this off back there. It's impossible, and I oppose.
Thank you.
You're welcome.
Anyone else? If not, raise your right hand, please. You swear to tell the truth about the testimony you're going to give.
Yes.
Name and address.
My name is Tina Roosevelt. Just going to continue where my husband Luke had first started talking.
You can finish his statement.
Thank you, I appreciate it. So again, I am personally opposed for myself and our family and in conjunction with the rest of the residents. So as far as our concern of timing, 1 year ago, the zoning board put Cooper Levinson on notice regarding the practice of giving residents less than 2 weeks' notice regarding this zoning decision. Again, we received a certified letter just over a week ago that was dated July 17th, providing residents with little time to respond. Upon receipt of this letter, we checked with some of our neighbors who had not yet received their notice. So we're asking if Cooper Levinson provided the board with copies of the signed notices to the families directly impacted by this request, so that the board can see the timing strategy used. It seems clear that this may be a tactic of providing late notice to residents as an attempt to mitigate the voices of the residents directly impacted by this petition. And it's unfortunate that this is the second time that this practice has been applied. Additionally, the attorney representing this matter noted at last year's meeting that they would notify their request within a reasonable time frame of 2 months, and now the residents are forced to respond again 12 months later. We want to again thank the board for your efforts over the years to minimize the overbuilding of our town. We really do appreciate that. We ask that you consider the environmental, financial, privacy, and day-to-day impact of these concerns that we've mentioned to all of these families adjacent to the property. The board has placed zoning restrictions in place for a reason, and this application to change the variance relief from 150 to 10 feet is in fact unreasonable given its impact on the surrounding residents. Thank you again for your time. Respectfully, we request that the board decline the variance relief requested. If consideration is to be given, all residents who reside on Lewis Court, Main Road, and Whitetail Pass require additional time and notice to understand our rights given such short notice by Cooper Levinson, so that we can secure appropriate representation in this matter. Thank you.
Thank you. Anyone else like to be heard? Raise your right hand, please. Swear to tell the truth about the testimony you're going to give. Name and address.
My name is Kimberly Hinson. I live at 2635 Main Road, the property directly next to the proposed variance here. Let me just start off by saying this has been a dark cloud over all of these neighbors' heads for the last year. I frankly think this is a waste of time for everyone here tonight. But it's nice to see you all, nice to see our representatives. So I just want to reiterate, I could read my speech from the last 2 times that I was here. I'm not going to waste your time with that. But nothing has changed from the last time we were here. The last 2 times, it's not safe. I'm extremely concerned being directly next to it. My bedroom is 39 feet from the property line. If he's going directly up to the property line, I have concerns about grading and about water runoff and stuff like that too. I have no room to spare because my well is right inside of my fence. And quite frankly, when this whole property went up for sale, my mother is a real estate agent. I tried to get information on the property, and Dave Beach had this sold out from under us before we even had a chance to get information on the property. So I don't really appreciate getting, hearing comments about how we all had an opportunity to buy because I could have bought you out. But anyway, regardless, I didn't know the property was even up for sale. There was a for sale sign in front of the property for maybe 2 days before Dave Beach put it as pending. And I work in real estate, so I have access to Bright MLS and the whole property history for the location. It's just very upsetting. Like I said, I'm happy to see you all here, but I think this is a giant waste of time. You have about 25 houses here that are affected by this, and we've been here for 3 years. This guy is just going to build and make his money and go. So, thank you very much.
Thank you. Anyone else? Raise your right hand, please. Swear to tell the truth about the testimony you're going to give. Do you swear to tell the truth?
I don't hear well.
Do you swear to tell the truth
Yes,
about the
I do.
testimony you're going to give?
Absolutely.
Name and address.
105 Lewis Court. Supposed to note that my backyard floods also when it rains, and I back up against this property. I also want to note or bring the attention to the board that this was here in December and turned down. It's been modified since. Under the environmental resource inventory, the eastern box turtle lives on that lot. It's a protected species. The reason part of the protection is in protecting its environment, which is the #1 cause for it to be endangered, and being hit by cars. It's listed on the New Jersey Wildlife EPA, and its status is endangered, and species. There's regulations on the books, on the New Jersey EPA and the New Jersey state website that says you don't do anything that disturbs the habitat of this turtle. You even need a permit to legally have one as a pet. And that's basically all I have to say. And I am opposed to any development behind my home at 105 Willis. When I bought that house, and I know other people have done the same thing, they bought the home with the understanding that that lot was landlocked and it would never be developed. And that's important to me. It was important to me 18 years ago when I bought the house that I live in now. That's pretty much it.
All right, thank you. Thank you. Anyone else? Raise your right hand, please. You swear to tell the truth about the testimony you're going to give.
Yes, my name is Jessica Slates. I live at 111 Lewis Court. I have been in my home since Salmar case, and family brought my husband to Delsea from Washington Township to buy that house. I picked out my lot when I was in the hospital after delivering my daughter. She was just 4 days old, and an old man Sal said, "This is going to be the best place that you live." And it has for 25 years. I have a 21-year-old that graduated from Delsea. I have a son that's going to go off to college next year, and I still have a 13-year-old. Where we live on Lewis Court, you can drive down. We've had fire trucks come down. You cannot drive a school bus down into the cul-de-sac of our neighborhood. So our kids get hooked up at the front of the lot. My other concern tonight was I heard about if there was to be a fire. Our lots are completely wooded. So if there was a fire and you could get a fire truck back there, you're still risking all of the 25 homes that we have in that area at risk for fire. And if we've seen anything this past year with wildfires and how quickly they can spread, you're not just talking about all of us on Lewis Court, all of us on Clark Court, all of us on Whitetail Pass. There is a massive community there that would be affected by a fire if we can't get to it. So I am completely opposed to this. And again, now hearing about the turtle as a special ed biology teacher and it being environmental, I oppose that as well. Thank you very much.
Anyone else? If not, is there a motion to close?
I make a motion, we close.
Second it. Second by Dan DeCesare. Second by Mike Garofalo. All in favor? Aye. Opposed? Any abstentions? You want to comment on some of those comments?
I want to address some of the comments. Mr. Denny, I know we spoke about this, but with respect to Whitetail Pass and that development and development on the other side, is there any stormwater management in place for those developments?
There is, and as the one resident had indicated, there's a basin that's at the rear of this lot that is not maintained and not meeting the requirements. So as a community, they need to band together to kind of maintain that basin and bring it up to standards so it can handle the runoff. So there is it's a planned development, so it has stormwater management, but unfortunately that basin is not maintained.
Or there additional comments with respect to the public?
Yeah, so the public had indicated about wildfires. In my opinion, I would say that being unoccupied is more prone for kids and teenagers to go in there and, I grew up along an old dump and they would light their Pragmites on fire and neighbors would go on. So right now, there is no access into that property at all. So that, if a fire were to start back there now, it's more dangerous than having a 10-foot wide access road getting back there. The applicant wants to make this his personal home. As you heard other residents here, they have built their families here, and after working in this town, Richmond has kids and would like to build the same stories these residents are building. But unfortunately, he's not able to do that with his lot because of the variance situation. That's it.
Mr. Chairman, just in summation, this is, in our opinion, this is a classic C1 variance. This is a hardship. The shape of the lot is an odd-shaped lot, and in order to access that lot, we need a variance. This was not a hardship created by my client. This is one that he inherited. And this is one that he inherited. And all he wants to do, he's actually proposing to build to do the least restrictive development of this property. One single home, which is on a 12-acre lot. Nobody's going to even see the lights in his house from all the trees surrounding. This is a very straightforward variance. I understand that this upsets a lot of people, but there's been no legal basis presented to say why that variance should not be granted.
Mike, there were a couple comments about noticing, and they weren't getting noticed, and that maybe you should explain to them how that works, because it really is out of our jurisdiction here.
Yeah, notice was properly given. They're only required to send notice 10 days before the hearing. So if it's postmarked 10 days before the hearing, that's all they're required to do. They did do that. If it doesn't get to you, it's not their fault. Fault of whatever happened from the time. They're not required to show the signed receipt. They're just required to show that they did send it. It can be exactly 10 days before. I reviewed it.
Did you get one for my property? Because this is the second year in a row I didn't get one.
I got one for every property.
Can I see that, please?
I don't know if I have it, but I did check off every single one. Maybe council has it. But I did check it knowing that last time there was some
And then when
notice issue.
I called the attorney's office and got the tracking number, I was missing the number, and I refused to call him back. So I'm just wondering if somebody can provide that information to me, because again, this is the second time in a row that I have not received a certified letter. And I am the property directly next to the requested variance.
I think he's going to check what he showed to me.
I've already spoken with Ms. Simpson. I provided the tracking number. If there's a number missing, I'll have her provide it, but we have a receipt for the property.
Can I see it?
Yes, absolutely.
Okay.
One question, John, since Ms. Simpson is speaking. I noticed you said something about being willing to buy that lot previously. I think we want to make sure that if she's still willing to buy it, that solves the problem.
My neighbors might honestly want to try to subdivide it at this point, but that wasn't something that was proposed. It was the whole 12 acres and some change when the letter went out. Way back a year ago. But like I said, I had tried to reach out to Dave Beach, who was the listing agent on it. He's actually the dual agent on it, and I couldn't get any information on it. Dave told us to reach out to the township, and that it wasn't buildable.
I don't want to interrupt you, but our solicitor said that they were notified properly, and that's all we can go by, so, you know.
Because the mail,
You can see it.
USPS, like, no record of it.
Mike?
All right, has
Every number that I received.
any other questions from the board?
And I work from home, so I can see when the mail's delivered, and no one tried to come to my door.
Any other
with
questions? If
anything.
not, I'm going to bring it up to the vote. Dave, you have any other
Nothing
comments?
further from an engineering perspective.
Gentlemen, any other comments?
This easement, they said it doesn't exist. So good, he's just taking 10 from somebody's property.
No, that lot was created with 10 feet.
I don't understand how that's not a concern.
So not that
She does have
the plan that created that lot with 10 feet.
Now, one thing we're gonna make clear, there were three hearings, but they were different.
All different.
Every single one. And one of them, people think that we just running over the same one over and over.
Yeah, so, any other comments from the board members? We want to make it clear that this is not the same here. We've had three, is it three? We've had 3 hearings, right? This is the third one. They've all been different. Because we can't hear the same thing twice. Is that correct, Mike? What is that legal term for that?
Res judicata.
Res judicata. We can't hear it twice, or they won't let it come back here.
The only thing that's different is there's a 1.5 foot difference in the proposed sidewalk.
That's the difference.
Okay, that's the difference, sure, but at the end of the day, it's
Okay.
still not safe for a fire truck.
All right, gentlemen, so you heard the testimony, you have any other further comments, what's your, and our professionals have no comments, you guys are finished with your rebuttal? Okay, what's your pleasure? Public portion is closed at this point. Need a motion?
I make a motion to deny.
Well, second. A motion by Dan DeCesare, second by Mike Garfolo to deny.
Mr. Gattano,
Yes on deny.
Mr. Hamel,
Yes for deny, yes.
Mr. Taraska,
Yes on deny.
Mr. Garofalo,
Yes.
Mr. Iglesias,
No.
Chairman Gravener.
No.
Oh, Mr. DeCesare, I'm sorry.
Yes.
So it's,
It's 1, 2, 3, 4, 5 yeses and 2 no.
they have enough? How many, what is it?
Five voted to deny.
Five,
It's
yes.
denied. Okay. Motion denied. All right, next on our agenda, ZB25-09, Greg Avis. Please come forward. Yeah, but I want to get moving. We'll get him out of here. We have one after you that's going to last a long time.
I understand. Represent Greg Davis on behalf of this matter. Mr. Davis is the contract buyer. We own the property on 139.
Please, people, we have a meeting going on here.
It's further identified as block 3102, lot 2.01. Oddly enough, this is a flag lot. Oddly enough.
Again.
This is a lot that was created by subdivision by the planning board in 1988. Really bad timing for this, but it is what it is. But again, the lot was created and perfected as a subdivision lot by planning board resolution 40-80. The subdivision was perfected by deed dated recording date of September 6, 1989. This was created and approved by the Franklinville Planning Board as a flag lot with a 25-foot flag with front. This is the same size and is noted in it will eventually get there in your engineer's review. We require two variances. Bulk variances to make this a buildable lot. The first one is lot frontage, 25, where it's not 50 is required, and lot size, 1.35 acres or 1.5 acres is required. Again, we're not here to create a lot, the lot's already there, but rather to get reapproval for this lot to be a buildable lot. Now, distinguishing feature here, this current lot is legally used as a residence for two mobile homes. The proposal is to get rid of those, along with the shed on the property, and create one single home. Approximately 2,200 square feet with garage boosting, adult with two-car garage boosting up to 25 square foot. But again, distinguishing features, 25 feet, which it seems would be more than sufficient to get a fire truck through. I never thought I'd have to bring that up tonight, but I'm here. And the fact that this property is already used for 2 residences, and we're gonna de-intensify these and make it a single family. It'll be a single family home, and as opposed to mobile homes. But those are the distinguishing features from our, this application.
You weren't here before, were you?
I'm sorry?
You said your previous application.
No, the prior application.
Oh, the other application.
Yeah. Which again, the irony of going back on this one is kind of funny. But I think the distinguishing features here, again, are 25 as opposed to something that's much less. And the fact that we're going from a 2 residence to a single residence. Mr. Avis is here, and I appreciate it.
Yep, raise your hand, please. Swear to tell the truth about the testimony you're giving. Name and address, please.
Gregory Avis, 112 Branch Road, Sewell, Missouri.
Demonstrate that you are the contract buyer of this property, right? And your purchase is contingent upon an approval for these 2 variances? Okay. And there are 2 adjoining properties that could be pertinent to this property, is that correct? Sure. Okay. And the one that's actually in the front, that's an undersized lot. Correct. Okay. And I believe that was the original sister lot of the minor subdivision. Our lot being the flag lot right in the back. And as shown in, fortunately, the engineer's pictures, a lot to the left of you actually has a residence right up against the property line. Is that correct? Okay. Yes. Purchasing additional property from the front lot would create a double problem. It's already an undersized lot with undersized frontage. So that would intensify that problem. And it's not practical to take it, to acquire it from the property to the left because of the situation, because of how the property is situated. Will you be building that home? And are there any other hardships required to be addressed for your proposed dwelling there? Mr. Chairman, that's Dave as well.
Dave, you want to go through your comments real quick?
Well, thank you. Our report was dated June 17, 2025. This is in the RA Residence Agriculture District. Applicant's attorney is correct. 2 variances attenuated to this. Lot area is 1.5 acres is required, 1.35 acres is what's existing. Street frontage is required to be 150 feet. There's 25 feet of lot width or street frontage. So those are the 2 variances that are required. You heard testimony that it's already being used for residential purposes, and that there are 2 mobile homes from the property that will be removed, along with all the other sheds and the other junk that's on that property. So photographs were provided showing the disarray of that property. So this will clean that up. The driveway is within a 25-foot wide stem, if you will, and it's an existing bituminous, existing paved driveway. And this lot was created as part of that. I was provided some information tonight. This lot was previously created and approved through the planning board back in 1989 in order to make that a buildable lot for those mobile homes.
It's unbelievable. They did that. Okay.
They did, yeah. So
both those pieces. Okay.
That's what we're up against. No, it's just planning issues, variance for lot area and a variance for street frontage.
Is that driveway on other property partially?
A portion of it is on the other property.
You realize that driveway coming in?
Driveway coming in.
It cuts into
Just
that
needs to be moved up to the left.
front lot a bit, as long as the applicant's there.
Oh, that little bit coming in there, yeah, you have to move your driveway.
Those two trailers are inhabited now,
Yeah, nobody lives there.
and nobody lives there at all.
They were vacated in anticipation.
And there's already an asphalt driveway going back there.
There's currently 2 septic beds or cesspools up there. We've got going on.
I know there's currently a well. I've done test bits for considered a septic design, but I'm not sure the current status of the system. I'm assuming the probably septic sitting out hold everything.
But we'll find out what it is.
So, just a question, out of curiosity, could they fix those trailers up and make them livable, and that would be,
Well, we heard that they're existing
is that,
trailers, right? So you can change owners and you can fix up your property, so yes.
so there could be 2 trailers with people living in them?
There
legally?
were. There were actually 12.
Okay, enough heard for me.
Mr. Avis, you're a builder, you're gonna build it for sale. So you're gonna do the whole lot. Build it for-
Is there a motion to open up to the public?
I made that motion.
A second.
Motion by Danny DeCesare, second by, Anthony Gaetano?
Yeah.
Is that you? All in favor?
Aye.
Opposed? Anybody from the public like to be heard regarding, this application? If not, we'll close the public.
I make the motion, we close the public portion.
Second.
Motion and a second, all in favor? Aye. Opposed?
I make the motion to approve the applicant.
I second that.
Who seconded?
Motion and a second.
Who seconded?
Gaetano.
Mr. Gaetano?
Yes.
Mr. Garofalo?
Yes.
Mr. DeCesare?
Yes.
Mr. Hamel?
Yes.
Mr. Tarasco?
Yes.
Mr. Iglesias?
Yes.
Chairman Gravener?
Yes. Thank you, very good. Put it up.
All he needs is 25 feet to get the other one done.
All right, Mike?
Yes, we're gonna go into a closed executive session to discuss the next application and the litigation attached to that. And there will be action taken when we come back. So we're going to discuss an agreement that was entered into. We're going to come back and have a hearing regarding the approval of that agreement, and then hopefully have a hearing regarding the application. It's like maybe 30 minutes is my estimate.
30 minutes for what?
Closed session.
Okay, is there a motion to go into closed session?
I make a motion, we go into closed session.
Motion by Danny DeCesare, second by Rich Iglesias. Okay, we're going into closed session. Where we going back there? Okay, is there a motion to come out of closed session?
I make that motion.
Motion by Danny DeCesare, second by Mike Garofalo, all in favor? So I guess we're here now to discuss the agreement, because we have some questions.
So let me start off, John,
Go ahead.
for the purpose of the public. What time we come? 8:30.
8:30.
Keep my notes up here. So the public notice mentions the Whispering Woods hearing. I want to make sure the public is aware of what we're doing tonight with this application. So this property was the subject of litigation. It was generated when this board denied an application by this applicant. As a result of that, an appeal was filed, and that appeal included the township as a party and the zoning board as a party. Eventually, that was resolved by way of an agreement. That agreement was signed by the township, but not by the zoning board. And before the zoning board can agree to or enter into that township, they have to have what's called a Whispering Woods hearing. Whispering Woods is, the name is simply related to a case that the courts said you have to have that kind of hearing. So before they can settle a pending lawsuit by changing something they previously denied, they have to have a public hearing on it and allow the public to comment if they wish, before they vote to agree or not agree. So this agreement has been signed by the applicant and by the township, but not by the zoning board. So what does this agreement basically encompass? So the agreement indicates that the property will no longer be used for pool manufacturing. no longer be used for outside storage of materials or supplies. A couple of exceptions that I'll mention. No parking or storage of trucks or of equipment. And there's a couple of exceptions to that as well. No repair of vehicles or equipment. No use as a contractor's yard. No construction equipment, manufacturing equipment, supplies, trucks, molds, cranes, pavers, transport trailers. No stockpiles of dirt, stone, supplies, vehicles, or equipment. So what would be allowed, if approved by this board in an application that could be heard tonight, if the agreement is approved, is 3 uses. The retail sale of pools in the existing building, the residential use, and agriculture in the rear of the property. So those would be the 3 uses that they would be asking to be approved tonight, along with a site plan for those. What the agreement provides that they can have outside is 14 pools to be stored outside, 11 of which would be behind the block building where the retail sales would take place. The other 3 would be up front, 2 of which you've probably seen, 2 or 3 when you're driving by them. There's also 2 movable trailers that would be allowed. Other than that, there'd be no other equipment or supplies or anything allowed outside. As most of you know, there's been a fire there that essentially eliminated this manufacturing regardless of what was going on. There is a ongoing DEP process in place. I'm sure you'll hear about on that as to what the results of that work. So what happens tonight is the public has a chance to comment on the agreement. It'll be the first hearing, so to speak. Council will have a chance to address any issues or concerns. The board will have a chance to ask questions, raise their concerns, and then they can vote on whether they are accepting the agreement or they are not. Assuming they did accept the agreement, then they can move on to hearing the actual application for the use variance and the site plan.
That's all tonight?
Yes, that application is part of what was filed and what the notice was about. Council, is that correct?
Yes. However, I will say this, just to elaborate more a little bit how we got here. As correctly indicated by your solicitor, there was a complaint filed on January 31st, 2022 by my client, I guess the township zoning board, that was the answer filed by the township and a counterclaim. And ultimately, what came about, how this resolution came about, was a settlement conference with Judge Kelsey, the assignment judge in Gloucester County, in which he sat both parties down for a settlement conference. And that's where the terms of the settlement agreement came about, ultimately memorializing the settlement agreement before you, that's dated February 27, 2024. We executed that agreement, settlement agreement, on February 26th. It was executed, township approved it by a resolution number 52-24 and executed, the mayor executed the same on the 27th, and that is what's before you tonight. But in order to fully understand the settlement agreement, what we're here tonight is not only for you to approve the settlement agreement, but the development that was contemplated as part of that settlement agreement. And I think for you to fully understand that, I don't know how you want to proceed, but I don't think you can fully grasp the settlement agreement until you see what the development is that we're proposing as part of that. So I would ask that we be allowed to proceed at least with regard to the testimony regarding the application for use variance, preliminary and final major site plan approval, so you can see and actually hear testimony regarding the actual development that was contemplated in the Whispering Wood, in the settlement agreement, which is now here tonight for the Whispering Woods.
But if this board doesn't approve the agreement, what's the point of moving on?
I was just, Mr. Chairman, I was just saying so that you have a better understanding of what was contemplated, that development contemplated in the settlement agreement, so that you fully understood everything before you voted on the settlement agreement. That was only my proposition.
So you're talking about a full presentation with planner and so forth, or just the explaining the development overview?
Going through everything and having it all voted for at the end. The settlement agreement, because again, I think the settlement agreement was entered into with 3 uses proposed, and I think in order to really fully understand those 3 uses and how they're going to be proposed on the site, you need to hear the use variance and preliminary and final major site plan. That is why in the settlement agreement it said, before we came here tonight, it's not as if that the settlement agreement, we could have went, if it was just a settlement agreement, we could have came before you back right after council voted on this. But that's not what was contemplated. What was contemplated is we would get a certificate of filing from Heinlein, make our application to your full application for use variance, preliminary and final major site plan, so you would have everything before you, and that you would hear the use variance, preliminary and final major site plan application at the same time that you reviewed and looked at the agreement. If it was just you voting on the agreement, we could have done that back in February or March of 2024.
I think we should have been part of the settlement agreement.
Well, your attorney was.
Included in that.
Your attorney took part in that. We had a settlement conference. It's you guys were represented through your council. Anyone could have attended. I know the township had the business administrator there when we had a settlement conference before Judge Kelsey. I can't talk or speak about why nobody from the planning board, or zoning board, I'm sorry, was in attendance at the settlement conference.
The business administrator isn't a member of the zoning board, so
Like I
he doesn't
said,
vote.
I don't represent the zoning board. I represent my client. I have my client in attendance. You would have to speak to your solicitor as to why you were not involved in that.
I explained to them that I did participate in the settlement negotiations, yes. They're aware of that. But the zoning board acts functions as a group.
Correct.
So, one person.
Listen, I can't speak as to why no member, Mr. Chairman, you weren't part of that or any other member. I wasn't your counsel, I didn't represent you, I can't speak to that. Your representative was there on your behalf negotiating this settlement agreement on your behalf, along with the solicitor for the township and the representative of the township, as was I on behalf of my client and my client. So, I can't speak to that.
Although as I recall, those who were in attendance did not participate. It was your client that participated, and the township administrator didn't participate in the discussion. They may have been listening in, but it was not a participatory process.
Correct. My client was there for me to ask questions to and to run things by, so that when the judge had a question, I could talk to my client and respond to the judge. It's similar to Mr. Madden, when he had the PA, so we could talk to him and find out, because there was some give and take on both ends to get to where we're at. Listen, with any settlement agreement, what I've learned throughout the time is that neither side walks away completely happy at the end of the day. It's usually a compromise, and that's what we have.
I think we have some questions, correct, gentlemen here? So we're going to ask some questions about the settlement agreement.
That's fine, Mr. Chairman.
I think one of the biggest questions is the environmental impact that it's had out there with the fire.
Okay.
And what's that, is the soil able to be formed? Are the wells able to be used? Is the water good?
Again, we are currently under the jurisdiction of the NJDEP. The NJDEP has issued a field directive in which they are requiring us to do, not in phase 1, because a phase 1 just gives you a historical analysis, doesn't mean any invasive testing. They're actually requiring us to do a phase 2 environmental report with invasive testing to have the property looked at. Once we get the results of the phase 2 environmental investigation, if need be, then we have to retain an LSRP, and we're going to have to go forward with a remedial investigation report, a remedial action plan, and obtain an RAO issued by the LSRP. But we are under the jurisdiction of the NJDEP, and the NJDEP is monitoring this and has given us certain things that we have to comply with. And quite honestly, not only, the difference is crazy about this, we don't have to comply with the NJDEP standards. We actually have to comply with the pilot standards, which are much more stringent with regard to the testing and the limits on what can be at the site. So since we're in the pilot, we're under their jurisdiction, we've got to meet their testing limits. So that is what we're currently doing. And we've hired an environmental investigation firm, Kalmar and Associates, who is currently performing that for us.
So if I just ask, pending that, so you can't really do anything with the property pending that, which may...
No, we can still operate the property. The only thing is if there's an effect on anything, it would be when we would be able, depending, again, we're assuming there is some, let's say there is a hit at some level, okay? Then we would have a remedial investigation report to determine the extent of whatever the contamination is, and then we would have a remedial action plan to remediate that. The LSR, we would then go forward and remediate that under the supervision of an LSRP, who would be John Marion, Calmar Associates. And then, once it is remediated, we would issue an RA. The only thing that would hinder on our property at all would be a portion of the area that we propose to be farmed.
Right, so if the board were to approve an application, they could make the farming conditioned upon you receiving those approvals, could they make it?
Again, we would ask for that use, and whatever area of the proposed farming use is impacted, that we would have to, that if we have, this is assuming that there's a hit, again, we don't know at this point, but assuming there is a hit, then we would be up to our LSRP. You know, is our LSRP giving us an RAO with restrictions? Is it going to have no restrictions?
What's the LSRP?
and RAO are?
We don't know what those...
LSRP is a licensed site remedial professional. There's no longer no further action letters that are issued by the NJDEP. The NJDEP did years ago was they started the licensed site remedial professional program, which otherwise known as an LSRP, in which there are now these licensed LSRPs that have taken the place of NJDEP personnel that supervise the remediation, and what used to be a no further action letter or an NFA is now separate. That's no longer comes out of the NJDEP. It's now called a response action outcome, or RAO, and it's issued by the LSRP, and that acts as similar to a no further action letter. The only difference is that with an RAO issued by an LSRP, the NJDEP has 3 years in which to audit that. Meaning that if the NJDEP within that 3-year time frame disagrees with the findings of the LSRP, then they can come in, audit that, and require us to do more things within that 3-year time frame. But again, we are subject to the NJDEP. They are having us do a phase 2 site investigation, and we are currently in the process of performing that, and we'll proceed accordingly. And we have to keep them monitored. And if there is a discharge that is discovered, we have to report that to them as well. And our LSRP, our environmental company, has an obligation, a legal obligation to report that. So that's currently where we're at right now with regards to that.
Thank you. Hey, guys have some questions? You did? Who actually owns the property?
Harding 870 LLC currently owns the property. That is another company of my kind that's just holding the property. That owns the property, and JC Company operates on the property. And Harding 870 LLC acquired it on November 1st, 2022.
Is Mr. Dalrymple the only member of that LLC?
Yes, of both.
Of both.
Of both.
Mr. Chairman, I'll leave it up to the discretion of the board. I have no objection to them making a presentation if they think that'll shed more light on the agreement. It's up to the board if they would like to hear either the entire application.
What do you guys want to do?
I think we should vote on whether we're going to approve the agreement or not first.
Well, then I'd be more than happy to answer any questions you have regarding what's being proposed here, any questions, other questions you may have regarding the settlement.
Did you make any of this up to the public? Well, I don't know. Does it get up to the public, Mike, too?
It does. Please, gentlemen, ask questions first, or you can wait.
Ask your questions now, then we'll open up to the public. Why do we need 14 pools?
We're actually not, but we've decided instead of 14, we proposed, instead of 3 in the front, 2 in the front, as you'll see as part of our plan, because we figured if 3 was too many. We didn't want 3 in the front, we just needed 1 here, 1 here, on both sides of the landscape buffers, and then 11 in the back. The 11 are our most prominent models that we want to be able to show to people. That was a compromise that was worked out as to the number. Obviously, we went up more. The municipality and zoning board wanted less, so 11 was the number that we compromised with Judge Kelsey. That's on the settlement conference.
Yeah, I mean, you go any place else, you look at the catalog and you pick out your pool. I don't think, they don't have 11 pools sitting there to look at.
So we have, we have 55 models. We have, obviously you have the catalog, you can look at it as well, but similar to going to Atlas pools or Alamo pools, there's always some pools on site for you to look at.
Yeah.
That's what we're proposing here. I mean, we're proposing, we're not actually installing these pools in the ground, but we're proposing is that so someone could see what they're actually, our most popular ones, they could see what they actually may buy. We're not proposing any spas on the property at all. That'll all be through the book. We have the same number of spas that we want.
That just seems kind of excessive.
Again, if you, that's compared to, that was a compromise compared to what else we had stored here and everything of that nature when we came down to it, what we absolutely was necessary to store at the site. And again, this was part of a discussion with the judge and a compromise back and forth. That's the exact number.
So if we disagree with the number and it gets approved, say we just say it's, you get 4 pools, and that's fireworks, it's National Night Out.
Oh, sorry. I was wondering what that was.
We're not under attack.
So the agreement says 11 in the back, we say we only want you to have 4, what happens? I'm just throwing that out there.
It would be up to them to either say that was something that they were willing to accept, or they could say it's a violation of the agreement. I guess it would be something they'd have to determine whether it was worth pursuing.
That may be, again, that may be something that we would have to reserve on with the judge.
See, that's why, what's the point of, if the agreement isn't approved here, what's the point of moving on with the application?
Again,
That's just my opinion.
Well,
I'm not saying it's not going to be approved, but...
Mr. Chairman, quite honestly, again, this is the first time hearing that none of you were involved in the settlement conference at all or part of it. Again, otherwise, the last, year and a half has been a waste of time. Us moving everything off of that property in accordance with the terms of the settlement agreement. We had to move everything off of that property. We did. In accordance with the terms of the settlement, I mean, we complied with the terms of the settlement agreement, thinking this was understood by all the parties at that time. I mean, it was very expensive to remove all those molds, everything off of that property, to remove everything there in accordance with the terms of the settlement agreement.
Do you have a number of how many pools were on there previously, just off the top of your head?
125 shells to go out and 55 holes. So again, we're down to 11. And at the same time, we're down to, we're allowed 14. We're not even proposing what we're allowed. We actually reduced it by 11 in the back and 2 in the front.
13.
After we put the site plan together, and we put out the expense, of engineering and going for use islands and everything else. My client put out a lot of expense, well into the 6 figures, in complying with the terms of the settlement agreement that he was required to comply with. And
that looks good out there.
To find out tonight that none of you knew about it. And
that's not correct.
I'll let your sister talk, but if you weren't involved in it, that bothers me a lot, because, that was not the understanding when we were at the settlement conference before Judge Kelsey. There was a settlement conference by the judge for a reason, and I'm not saying I know how the judge is going to feel, but, if I go back and say, Your Honor, we don't have a settlement agreement because the township had someone involved, I had someone involved, but the zoning board didn't, and had no idea what was going on that. I'll let you speak to your solicitor about that, but...
Well, that's not correct. It's not true. They did not know what was going on. They did know what was going on, but obviously the agreement is contingent upon the full board voting on the agreement.
But them not being involved in the settlement conference, Mike,
They were aware.
that's a problem.
They were aware.
You know, to find out that the chairman and none of the members were involved in the settlement conference, and that now is the first time they're seeing it or hearing it or have issues with this. This would have been nice if it was brought up before Judge Kelsey at the settlement conference, and if we would have had a chance to address it at that time in front of them.
Well, we're not attorneys, so.
No, I know that. Again, that'd be no difference than, you know, me agreeing to something and my client not being saying, why the hell did you agree to it? Well, no, my client needs to be aware of it. Again, it's, you know, it was well into the six figures my clients put out the line in terms of the settlement agreement, understanding that this was a settlement. I understand it has to be reviewed by you and approved by you, part of a Whispering Woods hearing, but this is something, if there was an issue with the settlement agreement, that could have been raised a lot earlier than this evening with regards to this.
Where do we move on from now? What's next, Mike, with this Whispering Woods hearing?
Well, either you want to hear their presentation on the application, it's up to you. If you want to have the public, at this point, talk about the agreement. If you want to have the whole package put together at once with everything, then have the public comment on that.
I think if we do that, it would be the way to go, just all at once. I know, it's up to, not up to me.
They're here to do the whole presentation, which was the intention. Which was the intention, so in order to have a full understanding of what they're doing, I have no objection to that.
But we have to vote on the settlement agreement.
What I'm saying is they think that for you to understand the details of what they're gonna do.
Okay, let's move on then. You all in agreement with that? Move on. Go ahead, move on with your presentation, then we'll, in the end, we'll vote on the settlement agreement, I guess.
Well, yeah, and the application.
And the application.
Thank you, Mr. Chairman. I mean,
This is not an easy one.
Before we move on, though, do you want to address any comments from the public regarding the settlement agreement? Just regarding that.
That's what I was just asked to solicitor.
I didn't know if you wanted to, yes,
We'll do that when we open up to the public, they can address it.
So again, we're here tonight for the development that was contemplated as part of the settlement agreement, which is now the application of JC Company LLC for use variance, preliminary and final major site plan, variance and waiver approval, pre-existing residential use, a retail swimming pool, sales use with outdoor display, and restoration of an agricultural use on lot 30 of lot 7101, also known as 870 Harding Highway. We are in your PHC Pinelands Highway Commercial District. We are asking for two waivers this evening regarding completeness. It is a waiver from section 253-33 F28, which requires a site plan containing a listing of other required permits from agencies having jurisdiction and the status of each permit required. We will provide that as a condition of being deemed complete. We also are requiring a waiver from section 253-33 F29, which requires a phase 1 environmental report be provided. As indicated, we are actually in the process of doing a phase 2, which is an invasive phase, testing phase, which is much more comprehensive than a phase 1, since we're already required to do that as part of a NJDP requirement. That is why we didn't proceed forward with phase 1, which is already in the process of doing phase 2. So with that, I would ask that, respect the request that you grant those waivers, I believe, and the application be deemed complete in accordance with the recommendation of your engineer. If you have any questions regarding completeness, I'll be happy to address them.
No, I think if our engineer deems it complete, we deem it complete. Okay? So.
Right, so there were those two items, item 28 and 29, that Mr. Walensky just spoke to. I think they've been addressed by that testimony, and the board could deem it complete, or I can deem it complete, whatever. But those were the only two outstanding items for completeness.
All right, so is there a motion to deem the application complete?
I'll make that
Motion by Daniel Cesare.
I'll second it.
Second by Michael Hall. All in favor? Aye. Opposed? Abstentions. Okay. Continue on.
Thank you, Mr. Chairman. We are asking tonight for 3 variances. We're asking for a variance from section 253, 184.2 to allow 2 banner signs, each with a sign area of 32 square feet, to be displayed within the pools in the front. Those I will present to you now, which we can mark as applicant's exhibit A1. The displays I'm talking about aren't banners that go across the entire pool.
Yep.
We are allowed, in accordance with section 253, 184.2J, section 253, 184.2C, and section 253-184.1C, we are entitled to 1 freestanding sign with a sign area of 32 square feet on each side. Since we already have the pools in accordance with the settlement agreement proposed in the front, here and here, we don't feel it's necessary to construct another structure to add a freestanding sign. Again, we'd like to propose the 32 square foot banner signs within the pool that pretty much look like they are, part of the pool itself. We are requesting a variance from section 253-181, which prevents merchandise from being located outside so as to constitute a sign. Based on the fact that the 2 pools are in the front, that is merchandise, just in case it's considered a sign, we are asking for a variance from that. And we are asking for a variance from section 253-164C, which requires a lot improved with a commercial use, whose side property line is adjacent to a pre-existing non-conforming residential use, to provide 75 feet landscape buffer along the property line. There is not a residential use on lot 28.01, that is off farm, and that is to the east of our property. To the west of our property, there is a pre-existing non-conforming residential use. However, that is 274.6 feet away from our actual commercial operation. Really, what is next to that is right next to the actual residential use that we're proposed and the agricultural use in the rear. So for those reasons, we are asking for a variance from that section for the 75-foot landscape buffer requirements. There also is a drainage easement that is located on that side of the property as well. So that actually goes from lot 30 over our property. So we are going to provide a 75-foot landscape buffer there as well. I have 3 witnesses with me this evening. I have John Dalrymple on behalf of the applicant. I have Kevin Dixon from Dixon Associates, and I have Tiffany and Morrissey, who will be further sworn in one at a time or all at once.
We can do it all at once, and we'll raise your right hand, please. Swear to tell the truth about the testimony you're going to give. Name, address, and credentials. And then we'll be...
Tiffany Morrissey, 7 Equestrian Drive in Galloway, New Jersey, professional planner.
Kevin Dixon, 313 Jimmy Leeds Road, Galloway Township.
So for the professionals, we certainly acknowledge them as being professionals in their field.
Thank you. So I won't waste time putting anyone's background in. I know Tiffany's testified before you.
Yes.
Multiple times. I don't know if Mr. Dixon has, but I appreciate that.
I think he has, yeah.
Okay, perfect. My first witness is going to be Mr. John Dalrymple. So I want to talk first about the retail sale of pools, the outdoor display on the property. The retail sale of pools is going to be conducted entirely within the commercial building, correct? Correct. And that is the building that currently is all concrete with the 3 garage bay doors, correct? Yes. And your hours of operation are Monday through Sunday from 9 a.m. to 6 p.m., correct? Correct. And you expect between 2 to 12 customers a day, correct? Correct. And you will have 2 employees that work in the commercial building, correct? Can you explain, let me ask this, since you acquired the commercial building, have you added any lighting to the commercial building? And you're not proposing any new lighting on this site, correct? You're not proposing any lighting to light up the pools on display in the back, correct? So you're going to leave the lighting as it exists currently, correct? Explain how trash is going to be handled for the commercial building. Very little trash is going to go into the office, to be collected by an independent trash collector. Now, the 11 pools that are on display in the back, you're not going to actually be selling those pools where they're loaded up on a trailer and taken to a customer's residence. When a customer comes, they have an opportunity to look at those pools in the rear and also at your catalog. And if they pick something out, you're going to have it manufactured out of your Lawrence Township site and ship it from there, correct? Correct. The turnover is very little, 1 to 2 times a year. Okay. And when you say the turnover, that's because maybe 1 to 2 times a year you may decide to change one of the models that you have on display and remove a model and put another model there. Is that correct? Correct. The colors and style change. Also, with regard to the necessity for the 11 pools, is that are the most popular models that you want to be able to display at this site in the region, correct? For customers to see, correct? And at the time that we had the settlement conference, we would want it to actually have substantially more pools on the property, is that correct? And you agreed at that conference to go to less than half what you wanted as part of a rather compromise with the zoning board and with the township, is that correct? Yes. Also, similar to other retail pool businesses that offer pool accessories such as robot cleaners, the skimmers, the pumps, the filters, you're also going to offer that at this location, correct? Yes. Okay. And that, the pool accessories will actually be stored in the 2 movable trailers, correct? Correct. Now I want to talk about the single-family home on the property. You're not proposing any addition or other change to the single-family home, is that correct? And you are currently residing in the home, correct? Correct. And you're intended to continue to reside in the home, correct? Let's talk about the agricultural in the back. Your intent is to lease that 6.51 acres to a farmer, correct? And you understand that there may be a delay in your ability to utilize all 6.51 acres until after we complete the NJDEP requirements regarding our site investigation. Is that correct? I have no further questions for Mr. Dalbert, unless the board has any questions.
Any questions?
Along with your pumps and everything, no chemicals, chlorine, anything like that? Small amount. Small amount? Very, very small amount. Couple buckets. And when you said, you're talking like shock and stuff like that, if somebody needs shock, that's got quantity as far as hazard.
Proper storage also.
Yeah, small amount.
Can I ask a question, Chair?
Sure. Can you explain to us how the pool display and the 11 pools in the back on turf, how that display is going to be oriented, how a prospective client would be able to look at these pools and see them?
Combination. See it, like how they go see it, or how they get to it, sorry.
Both.
You're going to be able to walk. In the display area that we proposed, we left enough room to fit the size of the pool, but also enough room for people to have walking alleys where people can walk from each model. Is that correct? Yes. Okay. And also, the pools, are they going to be propped up, or are they going to be combination depending on the style? And that's also depending, we say depending on style, depending on how large the deep end is, correct? So if you're proposing a smaller deep end, you can lay it flat so someone can look in. If you're proposing a pool with, let's say, a 7 or 8 foot deep end, then it would be propped up. Is that correct?
We were proposing steps or platforms that they can walk up and stand to look in, or you're going to have these pools propped up like you are, like currently out front?
Combination of both. And when we say a combination of both, the pools that you're going to have laying flat are pools that people can actually look into and see inside the entirety of the pool from that deck. We're talking about pools with smaller deep, such as 4 foot deep ends, you know, maybe 5 foot deep ends. We have approved steps with railing that would go in front of the ones that are popped up.
And you can hide 11 pools behind the building?
Yes, the 11 pools will be as displayed on our site plan, which you guys should have, which are all right here. And everything. They have to be behind, they're all behind here, between the rear of the building and the drainage ditch. And they're outside the 300-foot buffer, the quad wetlands buffer that's on the property. And again, like I said, the two that we're proposing in the front, we were allowed under the settlement agreement. We had thought we could do 3. But again, you know, after engineering this and looking at this site, we thought it was too much out front, so we decided to do 2. And at the same time, that is why we were also requesting, we don't want to build another freestanding sign structure. As I indicated, we'd rather just use, because we're already having the 2 pools in the front, just put a sign similar to what I handed out in each of the pools. Any other questions from Mr. Dalrymple?
I just have one question. So the house, you're not going to have any part of the house utilized as an office for the pool business?
I have a home office, but just myself personally, but you're not utilizing that as part of the pool business, correct?
Yes.
So the building you're going to use for the retail?
Nobody's coming to my house.
Right. So the building you're going to use for the retail, you have any problem with providing us with a floor plan that will show where customers will be, where your office will be? I think Mr. Shadid might have.
We actually, in the last application, we actually had provided pictures showing everything of the interior of the office. So we can provide we'll provide a floor plan.
And part and parcel with that,
You're not talking about architectural design.
we're talking, well, right, just how that's gonna be used, how the space is gonna be used inside. But part and parcel with that is, what is the building gonna look like after this improvements are done? Is it still gonna look like a garage?
No, we're not going to change.
That's what the board obviously wants to hear, what that building is gonna look like.
Looking to do a stucco facade front, eliminate probably 2 of the doors. You know, clean up the building.
So can you provide us with like an elevation, this drawing is going to show what you're proposing?
That's fine, we'll provide an elevation.
Stucco.
Oh, no, just to show.
No.
I'm sorry, he's thinking,
Sorry,
it's something.
I didn't understand the sign.
Yeah, we'll also provide that condition.
We know how high it is, right? That's what it is.
Any other questions, Mr. Dalrymple?
I don't.
In that case, my next witness is, Benson Associates.
Good evening.
Before we get into what the applicant is proposing here, I want to talk a little bit about the history of this site. And what I'm proposing or showing right now to the board was submitted as part of our site plan. So you have this history of historic areas. The commercial building that we're talking about has existed on this site in its current configuration since 1956. Is that correct?
At least as early as 1956. It shows up in historical aerial in 1956, probably before.
And according to the aerials, the single-family home was built sometime between 1963 and 1970. Is that correct?
Yes, those are the aerials that are available, and it's not in the 63 photo, it's in the 70 photo. So somewhere in that window, that home.
So the single-family home has existed on the property in its current configuration since 1970. Is that correct?
That's correct, at least 1970.
And You're familiar with zoning board resolution ZB15-12, correct?
Yes.
Okay, and in that resolution, the board found that the residential use was a pre-existing non-conforming use, correct?
Yes.
And that was the resolution that dealt with the seal coating line striping business, the agriculture, and also the residential use of the city, is that correct?
Yes, correct.
And the property, although currently not used for farming, was previously, the rear was used for farming from 1956 to 2021, is that correct?
Continuously, yes.
Now can you please explain what the applicant is proposing? Madam Clerk.
Referring to sheet 205 from the submitted documents that the board has, that sheet is titled demolition and site plan. There's a side-by-side view on that sheet that shows basically existing conditions as well as those conditions of the existing site. Some of those site conditions have changed, as you heard, and probably well aware of the fire that took that building down. 7,000 square foot building was originally proposed to be converted as the manufacturing was leaving into an agricultural building, storage of the farming equipment, supplies or whatever. That's all gone. So that building being gone, the entire back 6.51 acres behind the commercial building will be restored to agriculture. We heard there were conditions involved with that in terms of environmental, getting it cleared for that, but that is the intended proposed future use of that land, to be basically back to the farming agricultural land that it was before. In addition, I want to go back and just insert some information for the board. Back in 2015, there was a certificate of filing on this property that was received from the Pinelands. The Pinelands has been working from that point forward and identified a proposed parking area and in conjunction with that commercial building. So that proposed parking area is shown as in outline so that the board can see the comparison. But within that area, there's an expansion then of what was the 2015 area, which still needs to go to Pineland. But there's a substantial contraction of the aggregate and stone area and converting that area to turf on the easterly side of that property, pretty much the whole easterly side of that building. And that'll be the area that'll be green space. It'll be an area that would be, facilitate a small drainage basin, very shallow drainage basin that'll pick up runoff from the site. And the site will retain the 2,780 square foot building that was always there, at least since 1956, and put 12 parking spaces in front of it, including a handicap parking space and accessible entrances to the building. That area then will be blocked off visually, that is, with cedar trees from the residential use, so there'll be some screening separating those two uses. Such screening was never there before. But there was some vegetation in this area, in this yard, so that'll be restored to a red cedar type buffer between the commercial and the residential. The residential building will remain in residential use, and there will be a new septic system that will service both the existing commercial building and the residential use. That'll be a shared system.
And you just explained where the true pools in the front are going to be oriented and the 11 pools in the rear?
Absolutely. I skipped over that because I assumed it was covered. But yes, of course, you'll see these rectangular areas. Those are just they're 20 by 40 areas to demonstrate that they're basically a footprint where these pools will go. You'll see a rectangular area in the lower right corner. That would be the southeasterly corner of the site, and in the lower left corner, and these are behind those landscape buffers that are separating the project site from the highway. And those two areas will be the display areas up front, And if you look behind the commercial building, you'll see 11 of those spots set aside for displays just behind the building.
Thank you. Show them what the two movable trailers.
Yes. Am I talking about trying to project?
Yep.
All right. Once I have any left, so the movable trailers are going to be behind and to the left of the commercial building. You'll see them there within walking distance, and they're available to the accessories that were previously discussed. And they are south of the agricultural land set aside. They are also south of the drainage facility that is required to run through this property such that the adjacent farm field can drain through this property and along its natural flow path. And as well, the drainage basin that we're proposing is also on a spot that is facilitates the natural drainage path from the site going to this spot, and then from leaving this site going along its natural drainage path downstream. This site contains a wetlands buffer. The wetlands have been flagged and submitted to Pinelands. That buffer has been delineated on the plan, and that's shown. Now, that would be not developable from the retail perspective, but a wetlands buffer can be farmed with approved Pinelands approved crops, blueberries, cranberries, etc. There are those crops that can be planted in you farm a buffer. And I'm sure with the agriculture lands in this township, I'm sure you're well aware of that already. But I just wanted to point out the fact that that buffer exists. It's shown on the plan, and much of that buffer will be restored to agricultural land.
And also, we're removing a driveway encroachment that currently goes over lot 31, is that correct?
Yes, there was just some leakage, if you will, of the vehicles going around to get to the back of the previous operation. That'll all be restored such that there will be no vehicular traffic on the adjoining property. That'll be all cleaned up. And
also, on the plan, you had shown in the front existing 32 square foot sign, but there is no existing 32 square foot sign. Correct?
that was a drafting error that just should have been on the plan. There's no 32 square foot sign because where it says to remain, it's not even there. So just a drafting error.
And in your professional opinion, you think this 9.6 acre site accommodation for your uses?
Yes, the site is basically being almost reverted back to what it was originally. The retail use will be certainly a much cleaner and less intense use than the previous commercial use that was in that building. But other than that, it's essentially being reverted back to its original condition.
In your professional opinion, this represents a better development than what was previously proposed? Correct?
Yeah, better development previously proposed, better development than what was there before this.
Thank you. I have no further questions on Mr. Dixon. That's the board has any questions. My next witness is Ms. Tiffany Morrison.
Good evening. I know, I promise, Mr. Chairman, I will not be as long as sometimes I can be.
Ms.
Are you done yet? I didn't say that.
We'll make this quick. Obviously, we need use variance, for which we have to establish the positive criteria, and also you heard me indicate the C variance. Can you please just explain to the board how the positive criteria is satisfied with regard to both the use variance of the three proposed uses and also with regard to each of the whole thing?
Yes, so because this is a use variance, we have to demonstrate the positive and the negative criteria. The positive criteria relates to the purposes of zoning and the special reasons which are advanced. That those positive criteria would also apply in part to the bulk variances that we're requesting, because they would be requested under the C2 flexible fee standard. So I'm going to kind of wrap these together instead of giving testimony in two different ones, consolidate it into one bulk testimony to make everything a little bit more concise. So for the special reasons in this instance, we need a use variance because there are 3 uses proposed on this property, basically consistent with what the board approved in 2015, but different because it's a different commercial use. The 3 uses include the agricultural use, the wholesale use, and the residential use. The building that's going to be utilized for the pool sales has existed since 1956. The single-family unit has existed since at least 1970, maybe before that. And the commercial component that was approved on this property in 2017 will be basically reestablished in some component in terms of using this besides just for agricultural and residential. In terms of the special reasons and the criteria necessary under the municipal land use law, it's my professional opinion that this site would meet the criteria because it is particularly suited to the site and the use are particularly suited to one another and therefore promote the general welfare. Additionally, the application would provide an opportunity to advance purpose G of the municipal land use law, which is to provide sufficient space in an appropriate location for a variety of agricultural, residential, recreational, commercial, and industrial uses and open space, both public and private, according to their respective environmental requirements in order to meet all the needs of New Jersey citizens. Purpose 8, which is to encourage the location and design of transportation routes which will promote the free flow of traffic while discouraging the location of such facilities and routes which result in congestion and blight. And Purpose C, to provide adequate light, air, and open space. Why are those purposes advanced? First and foremost, there are unique features of this property and this use that create that particular suitability. Most importantly is the historical approvals and use of this property and the existing features that exist on this property. We have an existing commercial building, we have an existing residential building, and we have a lot that is 9.6 acres in size. This 9.6 acre lot is substantially larger than the minimum required lot size for your Pineland Highway commercial zone. For a commercial use to be developed in your Pineland Highway commercial zone, you need 3.4 acres. So we substantially exceed that. The area that we're using for the commercial is a small percentage of the entire property, allowing for that preservation of that open space and agricultural use to the rear of the property, consistent with much of the surrounding area. I will show you an aerial exhibit of the surrounding properties. Our property is located, I'm going to circle it so you can see it because it's not identified, but the site that we are at is here on Route 40, center of the plan, and you can see this side of Route 40 is the bottom of the plan, which is the north side of Route 40, I believe it's the north side, I did my arrow unit right, is our Pinelands Highway Commercial. The other side of Route 40 is your highway commercial outside of the Pinelands. Similar use is permitted in both. More intense use is permitted across the street. For instance, you're allowed to have drive-in restaurants across the street, but not on this side of the street. But when you look at the surrounding area, across the street we have some agricultural, some residential. There is an auto repair business. There is a leasing business with truck storage down the street, across from Garoppolo's and across from Sweet Amelia. And you have your agricultural uses. If you go further down the road, past Main Street, you have additional commercial uses such as Garoppolo, the RV dealership, more residential and agricultural uses, Delsey Bus Garage, building, dredging business, truck repair business, and a fence business. So you have a variety of uses along this area in your highway commercial district, both the Pineland and non-Pineland highway commercial district. So what we are proposing to do here is substantially consistent with what has been proposed and existing within your highway commercial zone. So we're not going out of character. This site, and because of that, provides sufficient space in an appropriate location for these 3 separate uses: the residential, the agricultural, and the commercial use. Your Pinelands Highway Commercial Zone permits a variety of commercial uses. It permits agricultural equipment of sales and services. So agricultural sales can be large equipment, backhoes, tractors, things of that nature. You have the ability to have building materials and garden supplies for sale. You have the ability to have restaurants. Automotive repair shops are permitted use, and convenience commercial is also permitted use, amongst other uses. So what we propose here is not substantially out of character in terms of the uses that are permitted in your Pinelands Highway Commercial Zone, and not substantially out of character with the uses that exist along Route 40. In terms of the adequate light, air, and open space, we are again preserving and about over 6.5 acres of the property is agriculture, so you have a large open space area instead of developing this as a fully permitted commercial use. And if you go back to that aerial, you can see the leasing facility across the street. It goes way far back. There is no, the zoning district goes to the back of this property, so technically the entire site could be used for some type of commercial use, so we're preserving that in the rear. We're also meeting your setbacks in terms of the front and side and rear yard setbacks, providing that adequate light, air, and open space, and with the changes and improvements that are required through the constitution of the agricultural use, we're reducing the coverage on this property and giving more open space and more pervious area on this property. Your setback requirements include 100-foot setback to the front, 20 to the side, 50 to the rear. We are addressing that. We do have that additional variance that deals with the buffer requirement. That would be to the property on the west. There is a buffer requirement to an existing residential use. That is a non-conforming residential use. As we indicated, that is over 270 feet from the property line where the commercial use is to the existing residential use, and between the two are the residential use that we propose to maintain. So it's my professional opinion and our position that providing that buffer, we really have a buffer because of the existing residential that's going to remain. And there is some landscaping and vegetation in the area sufficient to ensure that there's no negative impact to the surrounding area. That addresses all of the purposes of zoning I referenced except for the one about the transportation routes. It is appropriate to have a retail business, a commercial style business on a state highway in a commercial zoning district. This site provides that opportunity for that and advances that purpose of zoning as well. In terms of the positive criteria, I believe those positive purposes are advancing both the use variance and the bulk variances that we're requesting. With respect to the signage, we're still providing the allowable 32 square foot sign. We're allowed one 32 square foot sign, each side 64 square feet. So a banner in each pool is 32 square feet, so we're not exceeding the size of what would be allowed, meeting the intent of that settlement agreement by maximizing what's being provided out front instead of cluttering it up with additional signage. I think it makes a good use of the property and promotes the overall intent of providing the appropriate signage for commercial establishments. In terms of the negative criteria, is there a substantial impairment of your master plan, your zoning ordinance, or is there a substantial detriment to the public good? In my professional opinion, I don't believe there is. As I indicated, this area is in your Pinelands Highway Commercial Zone. On the south side of, or across the street, is the Highway Commercial Zone. This Pinelands Highway Commercial Zone was actually created in around 2004. We have several master plan reiterations that have been done, but in 2004 specifically, there was a decision by the town to create this opportunity for highway commercial between Main Road and Tuckahoe Road on Harding Highway, and it included what was considered both the Highway Commercial District and the Pinelands Highway Commercial District as part of the way to encourage economic development in the community. Now, since your 2004 master plan, there was a 2011 reexamination report, a 2013 reexamination report, and most recently a 2024 reexamination report. In your 2024 reexamination report, there was an update to your goals and objectives, a consolidation of assumptions, goals, and objectives, so that they were redone in terms of what's proposed under your master plan. Many of these, I believe, are advanced previous applications before you this evening, and these include the objective there's a goal number 1 to protect the rural character and quality of life in the township, and under that there are various objectives. One objective is to encourage growth and development in clusters rather than sprawling development, and in those areas near existing infrastructure in order to minimize impacts on the loss of open space, farmland, and forested areas. By allowing for this 3 uses on this property, we're preserving that 6.5 acres of farmland and advancing that rural character that does exist in this area, but balancing it with your economic growth and development. The master plan also included Assumption 5, which is the township will continue to seek to diversify and expand its economy. And under goal number 5, there are several objectives related to that, which include recognizing the importance of the agricultural industry to the local and regional economy, and promote policies and actions to support the local agricultural production, allowing for these three uses, not just changing it to fully commercial, promotes that purpose. To encourage economic development and industrial growth in those areas of the township that would have minimal impacts on residential communities. On Route 40, you made a distinct determination to create these highway commercial zones and permitting other commercial uses that are more intense than what's proposed here. This allows for that to continue and encourage it in an appropriate location, and to provide support for the growth and retention of businesses and industries currently located in Franklin Township. Your master plan included many other ordinance recommendations and updates. It included providing opportunities to protect residential and also including opportunities to encourage additional agricultural uses. This application before you, in my professional opinion, advances those purposes and those goals and objectives in your 2024 reexamination report. These three uses that are proposed on this property are not inconsistent with that. In terms of the enhanced burden of proof, one of the things your 2024 master plan recommended in terms of ordinances was an acknowledgement of existing non-conforming residential uses and providing an opportunity for them to remain even though they're in highway commercial zones. This kind of mixed use on this property really is not inconsistent with that objective of your master plan, and is addressed as part of those new goals and objectives in your master plan. For those reasons, I don't believe having three uses on this property with the pool sales, with the additional bulk variances that we're requesting, create a substantial impairment of your zoning ordinance for your master plan. Lastly, I do not believe we create a substantial detriment to the public good. In comparison to other permitted uses in your Pineland Highway Commercial Zone, other existing uses that have been approved in your highway commercial zone, both on the north and south side, and how this site would operate, it is less intense than those other permitted uses. We have limited the number of pools to just the retail sales and display. We have eliminated any of the manufacturing on site, and we've reduced the intensity of this site so that we have 6.5 acres of agricultural and limited retail sales and the residential use maintaining. We're updating the septic system, we're reinstituting the agricultural uses, and we're doing the environmental reports to meet the DEP requirements, all advancing good planning and practices and not creating a substantial detriment to the public good, and also not adding any additional lighting as was applied for in testimony. The number of employees are 2 employees on the site. Our hours of operation are not extensive, so they are not any greater than other permitted uses in the zone, therefore not creating a substantial detriment to the public good. I did it in my fast speed for you.
That's fast, that's a lot.
Yes.
Any questions for Ms. Morrison? Left it easy.
Okay.
Thank you.
You're very good.
Those are all the witnesses I have this evening, Mr. Chairman.
I'm sorry?
Those are all the witnesses I have this evening, Mr. Chairman. Obviously, I reserve the right to address any comments from the public.
Yeah, we'll go through our engineer's report now.
Thank you, Chairman. Our report was dated July 9, 2025, in which we reviewed this application. I'm going to jump all the way back to page 7, which starts with our technical comments. Yeah, Pinelands Highway Commercial Zone. The retail pool sales and outdoor display of pools is not permitted. And that's the testimony that was given to you this evening in support of that, for that use variance. Pool retail sales, also residential, is not permitted. We heard that it's a pre-existing non-conforming. There's also another variance associated with that, is the more than one principal use on one lot. As you heard, there'll be 3 principal uses on this lot. So, second D variance is required. My paragraph 3, I identified to the best of my ability what the proposal is, and that is backed up by testimony this evening. The only thing that was not included on paragraph 3, A through H, is the signs that we heard speak about tonight. That was not specifically included on the plans or the application. So
The display of the pools as a sign?
the signs in the pools.
Yeah.
Right, so the pools themselves are kind of a sign, and they're saying, hey, we got pools here and now they're for sale, call this number. So they're asking for relief for the signs. We call them banner signs. They're really not banner signs. They're affixed to the pool. They're not going to flap around. They're shown on applicant's Exhibit A1. And we've all seen it. So that will require relief from the board. Signs like that are not permitted. Signs, merchandise located outside to constitute a sign is not permitted. And the ordinance allows for one sign while they're proposing two. Now, the overall area is in conformance with what our ordinance talks about. It talks about 32 square foot per side of a sign. They're proposing 32 feet in one pool and 32 feet in another pool. So they don't exceed the area, but they do exceed the number of signs proposed. They're proposing two, where only one is permitted.
Well, what is in the settlement agreement? Is that?
That's not part of it.
I'm only talking about the site plan right now.
Yeah, that was not part of it, but are you willing to do a traditional sign instead of the pool? Instead
If
of
the
banner?
board wants us to add a sign out there, we will build a freestanding sign out there again, since the pools are going to be out there anyway. We didn't want to have to add another sign to the front. We just figured they're going to be there. If we fix something to the bottom of the pool that's similar in size to what we're allowed, we figure why add an additional structure? We'll leave it up to the board. It's your call. We don't necessarily have to do it that way. We can construct a freestanding sign that's 32 square feet on each side. I just didn't want another structure in the front of this property. I figured we're going to have the two pools there anyway. Wanted to make it simple, since the pools are merchandise and we got a variance for that anyway. Why not just put the 32 square foot sign in each and not exceed the total area we're allowed, but also not create an additional structure in the front there. We'll leave it up to the board. We just thought it was simpler and easier.
What slope will they be? Will they be standing straight up? Are they going to be, what tilt?
Sorry. They tilt back a little bit.
On their side or up?
Yes, on their side. They're not going to be up. They're going to be on their side, similar to, I think if you've driven by right here. Yeah, similar to what's in the picture. They're going to be on their side and everything else, and that's what's going to.
What supports on these? There's like, what they strap on?
I mean, what's anchoring?
Yeah, what's anchoring down so it doesn't blow across?
They're strapped back to 6x6 to the ground.
That's going to be something permanent, that strap that we're seeing in this?
Yeah, that's not. I don't know about that. For the backside.
You won't see it?
No, there's not going to be a strap. Yeah, that's. I just showed this as to show you what the sign will actually look like when I'm talking about it. I'm not talking about a banner that's hanging from
Yeah, I know.
I'm talking about something that's actually fixed at the bottom of the pool. But there won't be an actual strap.
I don't think we need an additional sign plus the two pools with signs on.
Correct, that's what we thought as well, so that's why we said, instead of, look, we're entitled, under your ordinance, we could build a freestanding sign, but we're like, why are we gonna add another sign if you're gonna consider the pool signs already under your ordinance, that merchandise in the front, just affix this to the bottom of it and not add another structure.
But they're not saying all three. In other words, they would not have the banners in the pool if they had the structure.
What I think the chairman was saying is, we're gonna have the pools there anyway. Why?
We can't change the pools out.
Correct. So why add something else other than, and I agree, and that's what was our thought process, Mr. Chairman.
As far as the orientation, I think it is within your discretion regarding whether the pools are standing up or laying more down. That's something that's aesthetic as well.
I know the board had articulated to me about how these pools are, what's the orientation, first of all, and then how do we know they're safe, right? And then, so that you give us A1 and it's got these ratchet straps on there. Well, could it be a condition of approval that the applicant provide us with some kind of a design certified by a professional engineer that, winds and stuff like that aren't gonna make these pools end
Yeah, I
up on
think
the
it's a good
highway?
idea.
Yeah, that's a great idea. I will do that. We don't promise that.
Okay.
Showing you exactly how they'll be anchored down and provided it to your professional engineer for you to deal with. That's fine. So we'll do that.
Good, Dave.
So let me jump back up to the top of my page 8. So the variance plan shows that the 2,780 square foot building, the block building, that garage will be converted to a retail store with 12 parking spaces for that retail use. It's not going to So the question that we asked earlier, I wanted to get it on the record, the applicant will provide for us, for our review, elevations of that garage, what it's going to look like. So it's going to a rendering, or something that we can say, hey, this garage isn't going to look like a garage anymore, it's going to look like a retail store. So show us what it's going to look like. Also, give us some idea of what the inside of it's going to look like. Some kind of floor plan, so we have an idea. I know you said there was only 2 employees, but is there going to be retail elements in there, stacked on shelves for sale? Just give us an idea of what's going on. Okay, so the 12 parking spaces are going to be in a reconfigured gravel parking area, something significantly less than is there now. My question is, the previous approval for the seal coating business required those driveways to be paved. Our ordinance says for retail parking, it needs to be paved, not dirt or stone. So a condition could be that this area be paved for the board's consideration, or grant the relief.
I don't want to say it.
We prefer to leave it stone as the way it is now, the way it's been in existence.
So, for the board's decision, pave it or not pave it, they're asking it for it not to be paved. I think that's waiver relief for not paving a stone parking area. They want to leave it the way it is, although it's pretty smaller than it is now, that gravel area. Those 12 parking spaces meet our ordinance requirement for number of parking spaces for retail use. There is a proposed ADA parking space. We're asking for details on size and how that's going to be constructed. The plan says it's on a concrete pad. However, if we're only doing one ADA parking space, it needs to be van accessible, so that'll have to be reviewed to make sure that that meets that criteria. That's a wider ADA parking space. So by paragraph 5 talks about the existing non-conforming residential use. I asked, are there any changes to this dwelling, or is the use proposed by this application? So we heard testimony that there's no change in this residential use other than a home office that perhaps was constructed there.
That's not a change in use. If you look
I
at ZB,
want to finish. So there was some altercations, but that home office is in no way open to the public, and is not directly affiliated with the residential, with the commercial use. Is that correct?
That is correct. And
Okay.
actually, in ZB 15-12, in that resolution, it specifically references an in-home office in the home, and that actually, all we do is move the location of that in-home office. It was already in the home.
One question on the home before we move on. Have you gotten the certificate of occupancy as of yet?
You can't get a certificate of occupancy legally. Under the Uniform Construction Code, and specifically, in order to get a certificate of occupancy under the Uniform Construction Code, and this is at NJAC 5.23-2.24, it says a certificate of occupancy, in order to get that, it must be conditioned upon the following: that the completed project meets the conditions of all prior approvals. That is a condition precedent that we have to have all prior approvals prior to getting a certificate of occupancy. The construction official has no authority to give a certificate of occupancy without all prior approvals.
Prior approvals is defined in NJAC 5:23-1.4, means the necessary certificates or approvals which are conditions precedent to the issuance of a certificate of occupancy. Prior approvals shall include, but not be limited to, the following: zoning. We're here tonight because to get zoning, because we don't have zoning, and Pinelands review. We don't have a no qualifier from Pinelands. So until the prior approval is conditioned, and under the UCC, the Uniform Construction Code, those two sections, they're conditions precedent to the issuance of a certificate of occupancy. Until we get an approval before this board and a no follow-up letter from Pinelands, the construction official has no authority whatsoever to issue a certificate of occupancy.
So your client's occupying the home, does he have an objection to applying for it, or letting the official tell him you can't, or maybe he will? Is there any reason
Well,
not to apply?
he puts his license on the line. If he does, do you really want me to make an application? I mean, look, I don't care if he issues it, though you're susceptible to, anyone can challenge that. You're asking the construction official to put his license on the line because he's not complying with the New Jersey Uniform Construction Code.
I'm not telling him what to do, I'm saying your client could apply for the CO, so he's showing a good faith to do that.
If you guys want to make that a condition of approval, we'll do it, but, under the Uniform Construction Code, I said it, the provisions, I'm just putting it on the record, that he doesn't have the authority to do it, okay, because we don't meet the conditions precedent until we get approval from the board.
In other words, no one can live in there until you get a CO either.
Well,
that would be the other.
Right?
Everyone's been living there. Actually, I did an Oprah request, and there's never been a CO issued for this property throughout, since the CO statute, ordinance went into effect. Every change of ownership, there's never been a CO issued. This is the first time it's actually raised, ironically, here and now. But as part of the settlement agreement, we agreed to get a CO. We just need to meet our conditions precedent, and that's it.
All I'm saying is apply, and then if they say no, you can't get it, but it seems like, since he's occupying it for safety reasons, they should get a CO, or apply first.
Actually, ironically, since we've taken ownership, the property, the municipality has issued permits for renovations to the property, even after we took ownership. So if the CO wasn't issued, they would have not been able to issue the permits. So again, I'm just saying, there were permits issued. And actually, that's part of the property record card that I submitted as part of this application. If you take a look at the property record card, it clearly shows that on 8/24/23, there were permits provided to my client for interior and exterior renovations. Again, if a certificate of occupancy was an issue, the construction office had no authority to give that permits at that point in time.
Okay.
Yeah, not extremely important issue, just raising
Go
the
ahead, Dave.
CO. Okay.
Next.
So my paragraph 6, and I think it's been addressed, but you provide testimony that all the previous but not approved uses on the site have been moved as part of your reliance
All the
on...
manufacturing aspects have been removed. It's all in the stuff. Everything in the stuff is going to be removed during the...
So the construction equipment that's
All
still
removed.
on site is not associated with that, or it will be removed, or it's a condition of the approval? I know most of the stuff has been removed, but there's still some stuff on the site.
There will be construction equipment here and on the site, specifically if we have to do anything regarding the remedial investigation. Since we have the ability to do some of that work ourselves with the LSRP present, we're going to do that. So if you see us drilling holes or anything of that nature on site, we're going to be doing that.
So
if
you're
you see
gonna-
a crane on site because we're moving one pool out for another pool, then that would be when you saw a crane on site. But that there will be no.
So you're not going to be keeping construction equipment on the
no,
site in
no,
anticipation
no.
of
There will be no
future...
construction equipment stored on this site.
Perfect. We heard about anticipated numbers of employees, visitors, site, hours of operation. How about number, type, and frequency of delivery vehicles? So I think we heard that 1 to 2 times per year you're going to change out these pools maybe. So is that really the only time we're going to see any pool delivery stuff, other than maybe a delivery for some retail?
No, and I apologize, Mr. Dalrymple, we went for quick. I meant to address this in Mr. Dalrymple's testimony. Mr. Dalrymple, the anticipated number of deliveries for retail use is probably, what, 1 delivery every 2 weeks? If that. Sales are great. That's no more than once a week. Right.
Thank you.
We anticipate 1 every 2 weeks.
based on the number of customers we anticipate to be selling.
And for that type of sale material, like a simple box truck, not a tractor trailer?
No tractor trailer, just simple box truck. There's no WB67 tractor trailers coming in here, nothing of that nature, no deliveries. That this is completely different than what was previously before this board was manufactured.
So you're not selling the pools, they're just for display? Somebody's not gonna pick it out and you're gonna take it?
As testified to, the pools are for display. If someone sees a pool they like, they will order that pool. It will be manufactured out of our manufacturing facility in Lawrence Township and then shipped from that facility directly to the property owner. The only time that any pool may be on the site will be moved or removed from there will be if we're changing a model out to put a new model in, maybe a new model he's created or a new popular model, put it there and take an old model off. And that's it. But you're not going to see, it's not as if there's going to be trucks pulling up and all of a sudden people are just picking up this pool. I want that one, that pool's going. So that's not how this operation works.
All right, landscaping. So the application, as we heard testimony, there's going to be a row of red cedars to separate the existing commercial use from the existing residential use on the site. You can see that on the plans. No other landscaping is proposed. So the board should determine if that existing landscape area in the front is sufficient or you want to see something a little more out there. But not much in the way of landscaping other than that screen row. Buffer strips. Our ordinance 253-164C3 says that we should have at least a 75-foot buffer. The applicant's asking for a waiver or relief from that section. Board should determine if those perimeter buffers, really need to be installed. So, our section of our ordinance says in this code it refers to that section that talks about the width of the buffers, or even able to increase the buffers as designated by the board. So since no buffers are proposed on the west between the existing residential on-site and the residential next door, no buffers proposed there, no buffers proposed in the back between the adjoining agriculture, and then no buffer is proposed between the commercial and the agricultural field to the east. So that's the way the plans are proposed. We should, if that's acceptable to the board, we should grant a variance for that. Agricultural buffer strips. So another variance that's required is the only indoor storage of goods is permitted on this site. We have outside storage and display of goods. So that's a variance the board should act on for this particular development. The pools are stored outside. The driveway encroachment on the adjoining lot, we heard testimony about that. The plans show that that's going to be rectified and that driveway encroachment is going to be removed. The plans call for a relocated trash enclosure, but no details are provided, so we ask that enclosure details, some kind of fencing with a gate, be proposed and shown on those plans.
We can amend the plan.
We just don't want to have a dumpster, a raw dumpster sitting there.
We will agree to amend the plan to show the details of the trash.
Paragraph 14 in my report talks about the ADA parking and signage. We heard testimony that that'll be addressed. Stormwater management calculations, groundwater mounding, all those stormwater management report stuff was not submitted to us originally, so we reserve the right to review that. Highlands will also be reviewing that as part of their letter of no call-up in light of the deviation between the inconsistent certificate of filing that was issued and the application that's proposed in front of us tonight. So that'll be a two-pronged approach between our office and Highlands for stormwater management. Paragraph 16 talks about signs again. We already went through that. Signs in the pools are proposed, and variance relief is required for that, along with the number of signs, one is allowed, two are proposed. Paragraph 17, talk about the pool display, how they're oriented, how they're going to be. We heard testimony that they're going to be on an angle, so the public can see it as they drive, and that's a full display system. We're going to get certification from a professional engineer that is safe. Paragraph 18 requires a letter of no call-up from the Pinelands to address the plans and also the NJDEP Pinelands requirements in order to make sure the site is safe and it's been remediated to regulation in order to have agricultural grown on that site, make sure that's soil safe. Site lighting. There's no new site lighting. There's a utility pole with a light on it. I don't know, there's no isolux lines. We heard testimony, it's going to be open till 6 o'clock at night. The board should decide if they want to have site lighting in that parking lot for the evening hours. It could be as easy as some site lighting on the building, but that's not
There's no
currently,
site lighting at all?
that's not currently proposed.
Yes,
There is.
We're currently, there's one large halogen, light in the front that does the whole parking lot. And then it's just the fraction. It would be required, closing at 6.
Yeah.
Whatever. Well, people going around the back of the building, look at the pools.
Existing lights?
Yeah.
No proposed. Okay.
You can walk around the whole parking lot at night. No problem.
In the pool display area in the back?
Yes.
And those lights will be extinguished in the evening? Or are they on 24/7?
They're all adjustable right now.
Just as on. I guess that's for security purposes.
Anybody ever steal a pool?
All you gotta do is cut the strap. All you gotta do is cut the strap.
Strap on top of your Corolla, there it is, take off.
Yeah, I would. I'd like to see the lighting on the revised plan.
Is that okay?
Paragraph 20 was about site contamination, and we heard testimony that a phase 2 study is currently being completed. That's all I have.
Okay. Your reviews are always the best, Steve, I want to tell you that. They're on point. How about we open this up to the public?
I make a motion, we open the public.
Second that.
Motion by Dana DeCesare, second by Anthony Gaetano. All in favor?
Aye.
Can we take that plan down there so we can see out there?
I just didn't know if anyone from the public wanted to look at it.
We'll just turn it somewhere, because I can't see out there. Anybody from the public like to be heard regarding this? Please come forward. Cindy? Pete? Raise your right hand. Do you swear to tell the truth about the testimony you're about to give?
I do.
Name and address, please.
Peter Capilano, 622 Rockford Road, Holland. The only issue I have right now, you guys didn't get a stormwater management plan on any of it, or any kind of drainage?
Good.
No.
Well, there's a stormwater management basin proposed between the crushed stone driveway and the property line to the east. It's a shallow drainage area.
This goes, when the gentleman put the building up, in front of the building, he put a additional pipe that comes right into my property. And I don't know if that's shown on the site plan, if that's taken into consideration. And somewhere there's mention of an easement for drainage.
I think that's
There's
where
never any easement on my property. So I should be taking that water from this lot on my property, should I?
Can you explain that to the design engineer, Mr. Kevin Dixon, where this easement, where this channel or pipe is, that you can say? Just so I'm clear too.
I'm going to start with the historical area, because it shows up pretty far back in time, actually.
Is this to the rear of between the agriculture and the
Yes.
commercial? That's what we're talking about, okay?
Yes, it drains from lot 31 through this lot, and the adjoining lot. There's a trench there that has been there consistently. You can pretty much see it in the aerial photographs behind the commercial building, year after year.
Not the stormwater management.
Your property? Yeah, this is my property. Well, this is gentleman put this right in over here, everything's down here.
What did I do?
I don't think you put it over here.
Did not appear, yeah, that does not appear to be anything that is from there.
Well, guess what?
From the day, first day I.
One of my workers came to me and said, you're digging a ditch on my
Sir,
property.
the only thing I've done is maintain it.
No, you dug a ditch,
You're inaccurate.
and then.
Inaccurate, we'll address it now.
No, I'm I'm just telling you what happened. My worker came over and said, the guy's gonna dig a ditch on your property. And I went over there and I spoke to you and I said, I don't want a ditch on my side. And you put it on your side.
No.
You were gonna dig through the fence.
Go ahead, make your statements.
That's my statement, and something's gotta be done about the water that's draining into my property.
Let me ask you something. I want to.
No, that's not how it works.
That one, and then you mentioned about buffering. Is he required to put buffering on my side, on the east side?
He's asking for a variance not to put.
Is in lieu of buffering, is there any kind of screening or fence?
We can make him put the buffer, if that's what you want.
I mean, we saw it was there before.
What was there
I don't
before?
want it to happen again.
Oh, no, what was there? Well, you would prefer to have a buffer.
Yeah, it's not a buffer screen, so we can't see all that stuff.
Like a fence.
Like a fence, not a screen.
A landscaping buffer screen would be acceptable?
I think the screening would be better than the buffer, because the buffer would hurt they won't have any room. And have an engineer look at the drainage on that side. That would be my bill.
Yep.
Okay?
Yep, good job. Anyone else? Raise your right hand, please. Swear to tell the truth about the testimony you're going to get.
Yes. Sam Durrell, 952 Harding Highway. As far as the ditch goes, the ditch was put in, I have permission from Ed Clark and Dallas Clevenger to drain that area. It comes from my place all the way down, because you saw how my lake was back in the day. That's where that came. That was before Pete bought it and he got it. So that's where the ditch came.
So there's always been a ditch there?
Yes, I didn't think it. They just made it, go it this way, that way, and then came back into the ditch. That was when I started, just before we built. Number one, is the state gonna have, apron put in for this project? Like all the other places, Bracco, DK and all that?
What do you mean, apron on the driveway?
Road access.
The state's not going to put it in, I can
No,
tell you that.
all the other projects had that put in. DK, Bracco, trailer place.
Well, that's on the state right away. I think they make that decision. We don't, correct?
Right, but you could, you know, if, like we talked about paving the parking area. If the parking area is not paved, I mean, if it's paved, then it's got to be
care of.
If it's going to remain the stone, there is some reasonable expectation to keep the stone on the property,
Not
and a
entirely.
paved driveway apron may be warranted. That would be an expense of the applicants. It wouldn't be done by the state, and you could make that a condition of approval.
All right, there's two wells that were on that property. There's one going to service the farm. There's one on the west front side and the east back side.
I don't know. They'll have to answer that question. Anybody else? Cindy? Raise your right hand, please. You swear to tell the truth about the testimony you're going to give.
Yes.
Name and address.
Roger Road. As far as the lighting, I don't know, the sign, is that going to be lit? How is that going to be lit?
I don't think they're lighting the sign.
Not lighting the sign.
Is there any, whatever you see there now is the site light that's going to be
Well,
there.
I never got there, I did, I don't know what really the property looks like. pretty bad. There was one time I went by there a couple of years ago. Anyway, the lighting, like one bright light in the middle of the parking lot, that can't be shielded, could be shielded for neighbors and everything,
we don't really know how bright the lights are.
driving, like the park, is that gonna be impervious, just covered, or is it already there?
The parking lot is stone, is what they're proposing.
It's all stone. I don't know, so, okay, well, anyway, so the lighting bothers me, and I would like to see, hopefully at some time after. Protect the neighbors.
Okay. Thank you.
Good.
Good, thank you.
So I know, I didn't really see the plan, so I know it did look like the landscaping was very good.
Thank you. Raise your right hand, please. Swear to tell the truth about the testimony you're going to give?
I do. I have a historical questions.
Name and address,
Kevin Kelton, Malaga, New Jersey. To the, I guess the engineer, he mentioned that what is being proposed is not a permitted use. Going back years with this company, they were operating sales. We'll call this the first use. I don't know how many years this goes back. Did this board ever approve in the past pool sales on this site? Did they get a variance from this board?
No.
They never had approvals from this board to sell pools on that site, ever?
This is the first time, right? Correct.
But haven't they been selling for years on that site, pools, retail sales?
Mike, you want to answer that question? There's been a lot of litigation.
That's why we're here, because we're going through the process. Applications and denials and litigation and so forth, but there has not been an approval here tonight. Request for that approval.
So at no time in the past, all the years that this particular company was JC Pools, have been selling out there with the pools, they never had approvals, but they were selling.
Correct.
And then on top of it, because I drove by there, I saw that there was a factory back there with smokestacks, and they were manufacturing pools. Did this board at any time in history ever approve manufacturing?
No, Kevin, no, we did not. And there was a settlement agreement made between the township and the applicant.
Okay, that's what brings us here tonight.
Correct.
And this board will vote, I guess, on this settlement agreement, whether this board will agree to this settlement agreement.
Our hands are kind of tied, Kevin.
In what way?
That the courts made this agreement with the township.
Right, but the courts also said that the zoning board gets to vote on it separately, right?
Yes. We're going to vote on the agreement tonight.
Okay.
Along with this application.
Okay.
For use variance.
I don't know how this board could possibly give this applicant approval for what's been going on in the past on this particular site. Thank you.
Raise your right hand, please. You swear to tell the truth about the testimony you're going to give.
I do.
Name and address.
Cindy Merckx, Malaga, New Jersey.
Go ahead.
Boy, I had so much to say, and I kind of am taken back because you guys had to make an approval, and I see 52 pages of Oprah request that I've had to make, and I still feel bad because you guys don't have all the facts, it seems. but I think your engineer's done a great job of putting everything together, and I'm sure Mike did too. But I'm sad to hear that you guys didn't get a say when it came to the real meat and potatoes that since 2022, they've been constantly in battle with going out there and saying, you can't do this, you can't do that. And then when the fire happened, Mr. DeCesare, I'm reading reports, and you've been a fireman a long time here. And I love our fire companies. And I can't tell you how we all prayed that day when you were out there. Because when you read the report by our chief of police, what he writes of the danger that he took the children out of our schools, okay? He took them out of 2 schools because he cared, because he didn't know what the chemicals were. Less than 20 years ago, I listened to the parents, over 100 of them, with Kitty College. Those parents were scared, and they were calling the papers, they were calling news agencies because they were afraid. And I know every one of you felt the same way. So all I'm going to say is, I'd love to see a nice pool company, to be honest with you. If it looks something like Bell Bell, or if it looks something, you know, like Myers Pools used to have, it would be nice for our community. But what happened that day, because of everybody ignoring it, is what I think is what really is on most of the people's minds in this community that I've lived in for 45 years. And I know you got to make a decision, and Mr. Gravener, I know you were the only ones who didn't sign it yet. I saw all the papers here where you're the only one they're waiting for your signature. And that's going to be a tough decision, so God bless all of you for what you have to do here, because none of you are paid for this job, not one of you. And you do it because you care about our community. So I'll leave you with that.
You swear to tell the truth about the testimony you're going to give?
I do.
Name and address.
Mark Pirella, 886 Harding Highway. The property will be right to the west of the residential property. I don't really have testimony as much as I do have questions. If I recall correctly, you said that the buffering is only for a small portion of the east side?
No, we're asking buffer requirements from the pre-existing non-conforming residential on your property to the commercial use. Supposed to be, it's required from a commercial use for both on lots. And the property line borders the pre-existing residential use, then you're required to have a 75-foot tower.
This is in, what you're proposing is within 75 feet of the property,
It's not, it's 275 feet from your property.
Well, that's what I just said, so the buffer would be in my property.
Where, no, we are required to still, even though we're 275 feet away, we're still required under the ordinance to put a 75-foot buffer. We're asking
Oh, no,
for
I understand that.
variance.
So you're not asking for relief on my side of the buffer, it's a small side of the
They are
No,
asking.
we're not asking for anything, we're not required to do it on the east, because we don't border a residential district or a pre-existing non-conforming residential use.
So if you're 275 feet away, why are you a violation of 75-foot buffer?
Because we're not the 75-foot buffer, it's a landscape buffer. That we would have to put landscaping 75 feet from the property line that borders your residence, 75 feet over, we would put a landscape buffer down that property line. We would, I don't even know how it would affect the easement or the drainage there. We'd have to put it all the way down through the agricultural direction. On that
But isn't
side.
that agricultural back?
It's not, doesn't matter. The way the ordinance reads is that if we're proposing a commercial use on the property, we're required to do a 75-foot buffer from a pre-existing residential use.
Okay.
And that's why, that's what you, but we're not required to do it on the other side.
And I guess my second question would be to you, if you agree and vote on this buffer variance tonight, you're voting on the existing plans, right? So if you give this variance, can they then move whatever they want up into the property line, or is it just a within
I don't understand the plan.
Thank you for clarification.
Past practices will tell us different.
Dave Marshall, 67 New Road, Malaga.
Swear to tell the truth about the testimony you're going to give?
I do. Most of the questions were already asked, but from someone that deals with a couple properties near me that do not keep up on their maintenance from a business standpoint, and the buffering absence on the one area, what happens down the road if somebody, if that farm becomes a residential area? when there's no buffering now, on the side that's having, or possibly getting away from that? Just curious. So you have one side that's not gonna have buffering, correct?
Both sides don't have buffer.
All right, so right now.
The only little buffer is between the residential house and the commercial building that has some shrubs being planted.
All right, so if that gets waived, you know, where there are none, and then houses get built down the road, which I know they're coming into it already with a pre-existing property. What happens at that point? Is there anything that has to be done, or they have to move in knowing that there's no buffer? That's what I figured, but I'm looking at it from the standpoint of, like I said, where I'm at now. And the buffering is an asset, you know, when you have a business that does not maintain it. I'm not saying you won't. Now, as for property maintenance, is there any type of performance bond or anything that gets done for how many years it has to be maintained? You know, for aesthetic purposes to make our township look nice.
Not to my knowledge. The township doesn't require that.
I mean, we have some businesses in town that are fantastic, keep up on perfect, and other ones that don't. So that's why I'm asking, you know, why is it something that can't be done on any business that's coming in? I'm not trying to pick on them per se, but why can't we have some kind of, something put in place to keep it aesthetically pleasing for the town?
It's a good idea. You gotta bring that up to the township committee.
Well, I have. Somehow there's some.
The dollar stores are a prime example of that. The dollar stores.
No, I know where I stand there. Again, these are just things I want to ask. Those are my only questions we're asking.
Okay, thanks,
Just looking at it from the standpoint as a resident.
Thank you. Anyone else like to be heard?
Got a whole minute left, Dave.
Not, we'll close the public portion. Motion to close?
I make a motion to close the public portion.
I second. Motion and a second, all in favor? Aye. Opposed? Okay. Do you have anything else you'd like to close with?
Yes, real quick, just to address a few issues. Is residential permitted, residential use permitted in any area around this property?
So we are in the Pineland Highway Commercial here. So the entire property, Pineland Highway Commercial Residential is not a permitted use. Across the street, Highway Commercial Residential, unless it's existing, is not a permitted use. Behind us is Pineland Agricultural Production. Pineland will not let you build, maybe you can build a house if you have a farm, but that's about all that's allowed. So you're not going to get that kind of residential development.
Unless they change the zoning.
Pinelands change the zoning?
Just zoning in
From
general.
agricultural production to residential, I will roll over in my grave.
The likelihood of that, is I represent a town, a big Pinelands town. No, thank you, Mr. Chairman, and members of the board for allowing our application this evening. I hope that people will better understand why the terms of the settlement are what they are, and the development is part of the settlement agreement. We respectfully requesting that you approve the settlement agreement and also the application for both variances. Again, this has been a long, arduous process. It started in 2000 and beginning of 2022. Going now for 3.5 years with litigation. We are asking here, as shown in historical arrows, we've always been a commercial building on that site in some aspect. It's been a 3-day drive. Prove that and testimony to, and actually make that nicer to that is. There's always been that cultural component on the property up until 2021. And there's always been a single-family residential use on that property since 1997. This property has had 3 uses on the site. Previously, it was granted a use variance for residential use and agricultural use. We're looking to put this property back into.
You must be getting tired because your voice is fading. I can hardly hear you.
The condition that it was in prior, so again, we are just requesting you put the settlement agreement in this.
Thank you. Phew.
I know it's a lot.
That was a lot. All right, so I think the first thing we have to address, obviously, is the settlement agreement, which I think our hands are tied. We don't have much of a choice according to both of our attorneys here tonight.
Well,
put some stipulations, but
yeah, I mean, you have some items, if you approve the, site plan, you have some items, you have some discretion on regarding the signage, regarding paving,
but
lighting.
not the number of pools.
Not the number of pools unless it's agreed upon.
And again, we have agreed, we're not going to go to the 14.
Thanks. Thanks for that one pool.
I know you did, it's on.
But I mean, just to clarify, because council made some comments that made it sound as if I wasn't properly carrying out my responsibilities. I think I need to address that. First of all, I am recommending approval of the agreement. I think it's based upon all the litigation that's been ongoing. The fact that we got rid of the manufacturing and we have a control over a site plan, I am recommending approval of it. As far as the impression given by council that it had been pre-approved by you is not correct. The settlement conference with the judge was not the final agreement. The township committee had to vote on it. They had to adopt the resolution, so it was not agreed upon with the judge. It had to be done by the township by way of resolution in the entire township committee, the same as it's required to be done by you by majority vote and a resolution. So it was not something that was agreed upon in advance. I did advise the board of the ongoing negotiations. And the agreement does indicate specifically the township approval is subject to zoning board approval. And I only add one other thing, since I said council seemed to have been attacking my representation. When we appeared before the judge for council fees, Mr. Malinsky's position regarding my council fees for this board was that I was not entitled to them because you had not yet entered into the agreement. So, a little bit inconsistent. That all being said, I am recommending the agreement. Okay, I just wanted to clarify I was carrying out my responsibilities properly. I recommend the approval of the agreement. As far as the use variances and site plan, I think you have some discretion on some of the areas we talked about to
Very little.
make it a little bit better. Not a whole lot, but yeah. So the basic concept of a pool business and an agricultural and the house is what they're applying for, and you have some discretion on some of the details, not all.
Okay. Is there a motion to accept the settlement agreement?
Wait a minute. I got a problem with this whole thing. We have an entity that's never followed any rules that have been imposed upon them. And now we're supposed to enter into something like this where, again, what's going to happen? Are we going to go willy-nilly like before? Things were constructed, things were done, and nobody cared. So I'm not too keen on it.
Okay, I can address that. Now you have a settlement agreement, which, as your counsel indicated, is not looking to enforce the settlement agreement. As the judge, or an order forcing us to do, comply with the settlement agreement. And again, in the settlement agreement, if a motion to enforce is required, not only will be a court order required to do this, you would be entitled to your attorney's fees and costs as you file that motion to enforce. So there's more than just. There's actually teeth to this now where you have a legal mechanism in which to appear before the judge and force us to do what we're required to do according to the settlement agreement, which didn't exist.
So they didn't comply before because there was no legal gun to their head?
Well, no. Going back to the details when we started this, there was an equitable estoppel claim in our initial complaint regarding the zoning permit that was issued. We went through the history last time. That's the basis of why we filed our litigation. At the end of the day, based on our claims, and again, the township filed an answer and a counterclaim based on everything every party sat together before Judge Telsey and negotiated the terms of the settlement at that time. The settlement was scheduled by, but based on some of the actions that were taken by your construction department, by your zoning officer, during the period of time when we were operating, we relied upon that and our detriment and moved forward. And again, it goes back to lay out to the judge, and that's when the settlement conference and the Department of Settlement Conference coming out before the settlement.
Okay, again,
Well, as far as enforcement, I mean, it's like any other application.
it's the
but
same thing.
If you do a resolution that they can do what they can do on the property,
They do it.
it's out of the hands of the zoning board. After that, it's an enforcement issue with the township.
All right, I'll make a motion that we accept the agreement as submitted, okay? Even though I'm not particularly keen about the whole thing. But with the recommendation of our solicitor, that's my motion. Is there a second?
I'll second it.
Second by Mike Garfolo.
Mr. Gattano.
Well, I have to give it a slight recommendation that we prove it, so yes.
Yes, that's a yes.
Mr. Garafalo.
Yes.
Mr. DeCesare.
No.
Mr. Hamel.
Yes, I also don't particularly like the decision, but if we're looking forward, not looking past, I hope Mr. Dalrymple does what he has laid out here and has a successful business.
Mr. Tarasco.
Yes.
Mr. Iglesias.
No.
Chairman Gravener.
Yes. All right, now to the use variance in the site plan. Now, Dave, this drainage easement, this ditch, it's not on the plan. How do we handle that? I mean, it can't be draining water on other people's property, correct?
Well,
Forget the concrete.
we heard a couple of different things. So we heard testimony that the aerial map shows that it's been there for as long back as those photographs are there. And then we heard testimony also that that ditch had been constructed with the approval of others.
And you also had Mr. Burrell testify that it was going to be recorded with the pictures that it's been there forever.
Correct.
And also, where would the water drain to if it wasn't already there? What we can say is we did not dig it. According to Mr. Burrell's recollection of the aerial photographs, we did not dig it.
And there's going to be a retention pond, Dave?
Yes.
Are you still gonna get details on the drainage?
Where's that going?
We submitted details on the drainage management.
That came later, right after your initial application.
We submitted it.
It was after my review.
We submitted that on July 10th. We submitted the stormwater management report, the stormwater maintenance reports, and our engineer's estimated costs on July 10th.
After the completion of my review.
Correct.
In response to my review.
Correct. And we did submit it, and that was almost 30 days ago that we submitted it prior to the hearing today. Technically, we have to have things on file under the MLUL 10 days prior to the hearing. We submitted it almost 30 days beforehand to give your professional time to review.
But that little basin is the only basin they're having?
That's correct.
And,
But that drainage easement, they said, is behind all that.
That's, yeah, outside. That's downstream from the basin. So the basin will pick up stormwater runoff from the
parking lot and
from
everything.
the parking lot area and not contribute it directly off-site, not to that easement.
All right, gentlemen. Need a motion.
Okay, thank you.
Need a motion to,
All together?
Just to I think you asked whether you're gonna do the use variance and site plan together.
Yeah.
Or some of the outstanding items, just to clarify, it agreed to a floor plan and then more than an elevation for the building, revised plans for lighting, landscaping, and some other items that were discussed. You would have to decide whether you want to have allow the banners on the pools or a separate sign instead. They're going to have to comply with Pinelands and DEP regarding remediation in their process of doing a phase 2 on that. And the decision regarding paving or an apron, would have to pave it in entirety or an apron.
You'd have to, no matter what. Really Stone cement parking lot. Can't put that on.
And how about the one of the
Fence on the east side.
Oh, the fence on the east side. Screening
on the east side.
Is that a motion you're making, Mr. Gaetano?
No, we're just listening, updating the listener.
I think you should make the motion.
Can we make the motion? I'll make the motion to approve that, with those conditions.
Screen
You have a fence?
On Mrs. Capilato's property.
Right, we don't have to provide screening.
You have a fence there now?
Yeah, in fact, we already have that.
I'm not sure.
There's some kind of fence right here. To here.
Yeah, there's no. It's all farm, there's no residential.
Right.
No one left the property line. To the ditch.
So, what are we saying here?
We grant relief for the perimeter buffer or not?
The only buffer we're required to have is sewer theory, on the west side.
But we still can we can ask you to come on the east side, whether,
Right, you can make that a condition based upon the testimony provided, yes.
All farm, residential use. And wetlands, actually. If you look at the plan, most of it, I mean, they already have a wetlands buffer that we can't encroach within anyway on most of the property. And in here, we're having our stormwater management, so there's not gonna be anything there anyway. We have a stormwater management basin, so there
do you have
really.
to have a fence around that, Dave, or no?
It would depend on the depth.
Around the retention pond, or whatever it is.
No, the pond does not propose any fencing around it, nor landscaping around it. It's just a hole in the ground there, in that whole turf area, between this proposed stone parking and the eastern property line. You can see it on page 3.
Don't they normally have fences around them of some sort, split rail fence, anything?
How deep the retention pond happens. How deep's that pond? That's it.
It's not a pond, it's a, right?
It's a depression.
There's a fence in the depression.
5 minus.
It's only a foot, I think.
Could have to be grass on private property, not adjacent to any residential structures. Your decision.
Mr. Gaetano, you made the motion. Do you want a screening fence there or not?
It's not even that deep. It's just, once it's maintained, it's not. That's fine, we have a maintenance plan that we've submitted that we have to comply with. Again, I've seen a lot of those maintenance plans fail. What's that? I've seen a lot of those maintenance plans fail. No, but now they're required to be recorded and enforced.
Okay. Anything else we missed on that motion?
The paving or apron?
I think it should be paved. Everybody else has to pave.
Even apron.
No, paving the whole parking lot.
Paving the whole parking lot.
Paving the whole parking lot. Now that you're doing that, does that basin have to get deep to pave?
Not substantially.
Not a very big portion.
No, Highlands treats crushed stone as impervious because it's going to get crushed.
Could figure that out.
And packed down, so
Yeah.
no significant changes.
Okay.
You want to,
All right, so
reiterate that one there, Mike? Talk through that again.
Well, everything that was agreed upon on the record by the applicant, as well as, you're saying the motion includes paving of the entire parking lot.
Yes.
Did you want to do a freestanding sign and no banners in the pools, or you want to have a banner sign in one pool or both pools?
Well, I think the banner inside the pool, that's a vinyl wrap. It's on there. It's not going to blow around, and it's one less thing
Is the angle of the pool acceptable if they have the certification from an engineer?
We definitely need that. We agree.
Those agree.
You're gonna see the angle and the, how you're gonna tie it down, right?
Any additional landscaping, or you satisfied with?
We're not landscape designers, how do we know where the landscape is?
Okay.
So there is no landscape.
Well, there's already 2 beds in the front, right?
Yeah.
Where do you think the landscaping should go?
On top of the roof.
Back
With the elevation.
The only other thing was discussed was the lighting. There was a comment whether it should be shielded or whether there should be any other lighting.
Yeah, we're not adding any lighting. My client lives right next door. There's no light seepage into his house or anything of that nature.
What was the distance to the next closest residential?
800 feet to the, approximately 800 feet to the east and 274.6 feet to the west.
You sure? Okay, anything else? That cover all the variances we need and?
It's a lot of listed.
And I guess no buffer? Right?
It's up to you.
I know. No buffer is required on either side.
On the west, there is. On the west, because closest to the west, which is...
Between the house and the commercial property, that's the only buffer you have.
Correct. We have that's it, between the house and I'm talking about not the single-family residential we are providing. The buffers would be from the property line that borders the other house to the door, I think on the Burrell property. On the west.
Right.
Where that farming operation we would have to do. That's where the buffer is only required. And again, our commercial building is 274.6 acres. And it's actually a residential house is what's really right next to it. Good asset. It's
What do you think, Andy?
So as long as they stick to what they say they're gonna do, it shouldn't be a problem for any residential neighbor, but if they begin moving a bunch of stuff in and doing a bunch of things again.
I'll go back to.
I mean, a landscape buffer wouldn't hurt down that side.
There's a site plan that's going to be on file, we're going to have to comply with. Not only that, like I said already, there's a settlement agreement that the court that will be.
I think he just said that he wants to put that landscape buffer on that west side.
It sure wouldn't hurt to block off that nearest
In the
residential
motion.
property.
On the, well, we have our residential, well, how big of a.
I understand.
We have our house right there, and then they have theirs.
A row of trees or something.
There's the row of trees.
That's what I
You
was saying.
have a row of red cedars down between the one use and the other use. Maybe another row of red cedars mixed with some white pines down the residential property line.
Can we have, obviously, we're proposing agriculture in the rear. Can we?
Oh, sure, I didn't mean for the whole entire length.
Well, that's what I'm trying to get at. What are we talking about?
Let's take a quick measurement. I got my scale here. Be careful, it's losing a lot of energy, but I know it's, okay, I'm fading too. I didn't need to do this.
That row of red cedars on the plan there, right there, that's about 110 feet long.
Yeah.
Would you like us to do something similar on the other side?
Yeah, duplicate it on the other side.
If you went 240 feet back from the edge of pavement, that would put you well between the residential property next door. 250 feet buffer extending from Route 40, edge of pavement.
Both sides, Andy?
I don't
I'm talking about the one side.
Yeah.
One side is it.
Correct. The west side.
Right here.
Okay, that's the motion.
From the, and check all the boxes there.
I didn't have to listen. All right, you want to add anything else to that motion? You're gonna pave the parking lot, you're gonna do the buffer on the west side, 240 feet, you said, Andy?
Yeah, 250 feet covers past the next residential property.
Okay. That covers it?
Yeah, the only thing I would
No,
add
we
is...
would ask to just keep the existing trees that are there.
Well,
There are some existing trees already, we'd ask to be able to work through them and around them.
Yeah,
Oh, I don't think you can take any trees down.
Yeah, we don't want to take any trees
just
down.
add to them, that's all.
Yeah, we'll just add to them, that's all we want to do. We don't want to have to remove any trees or anything like that.
Yeah,
But there are some nice
large
existing trees.
30-inch diameter trees there, I wouldn't suggest.
Yeah,
taking.
that's all I want to make sure. I didn't want any confusion, we got to take those out and put this in.
There's going to be the revised plan is subject to review by our engineer for compliance. Another thing I would add is you'll copy our engineer on all the correspondence with DEP, so we're aware of the progress of them and the Pinelands. I have no other.
Well, we got that floor plan in there too.
Yeah.
Yes.
On Peter's side?
No.
Okay, you cover everything? There's a motion by Mr. Gaetano, is there a second? On all those conditions?
I would second those conditions.
Second by, Andy?
Mr. Gaetano?
Yes.
Mr. Garofalo?
Yes.
Mr. DeCesare?
Yeah.
Mr. Hamel?
Yes.
Mr. Tarasca?
Yes.
Mr. Iglesias?
With reservations, yes.
And Chairman Greener?
Yes.
Chairman, members of the board, thank you very much.
I don't know how hard this was. It's probably one of the hardest ones we have. There we go. Okay. Resolutions, Mike, any resolutions?
Let me find the agenda here.
Henrighty,
28, or DP 2507.
one resolution, Henrighty.
Is there a motion to approve?
I make a motion, we approve the resolution.
Motion by Danny DeCesare, second by Mike Garofalo, all in favor, aye.
Aye.
Abstentions?
wasn't here.
Secretary's report, anything, Chrissy?
No.
No more discussion. Motion to adjourn.
I make a motion, we adjourn.
Second. All in favor? Aye. Oh, God, that was a disaster.
You guys are out now?
No,